Good, so welcome. Good afternoon, good morning, or good evening. It depends on where are you now to join us. Welcome to this, it's a conference, it's longer than a webinar. It will take roughly 4 hours. So thanks for dedicating such a big portion of your day to attend this conference. Let me start by thanking, in the first place, the two institutions that are hosting this event. The Labor Law Community, an Italian association which is very active also internationally, and the Department of Business Law at Lund University. I won't say more on this because we will have the two representatives of the institutions soon after my introduction. And then, of course, the big and the most, the warmest thank goes to all the panelists and the discussant who kindly accept to undertake this task to talk and discuss and exchange reflections on the proposal from the Commission on the so-called AI Act. So I will give you now a few practical information about the structure of the event, and then I will present you all the speakers for today. So we have an event that is split in two parts, in two sessions. The first session, which will start soon after the greetings from Marcia and Jürgen, is a general session, and we will have the contributions from Guido Smorto at the University of Palermo with a paper titled "A Risk-Based Approach to AI Regulation." And then we will have Michael Vale from University College of London with a paper titled The AI Act and the Product Safety Paradigm, Adjustments Needed. And then we will have Rosanna Fanni from CEST and Brookings Institution with a presentation entitled The EU's Regulatory Proposal, AI Policy in the Making. And then we will close this first session with Frank Pasquale from Brooklyn Law School, who will present a paper entitled Anticipating Employer Resistance and Regulatory Arbitrage, a US Perspective. After this very first session, after these 4 presentations, we will open up the floor for Q&As. And then after that, at 15:45, we will have a break. Around 4:15. So we will have a break of 10-15 minutes, and then we will start the second session, which is more focused on labor law. We will have 3 presentations. The first one from Miriam Kuhlmann, who is actually at WU Vienna, but also visiting research at Harvard University. As her presentation is called On Discrimination and Privacy. Then we will have Odd Cefaliello from ETUI. She will present a paper called Making AI Safe for Users. What about workers and OSH perspective? And then we will have Valerio De Stefano from KU Leuven with this presentation entitled The Potential Threat to Labor and Fundamental Rights. And then after these 3 presentations, we will have Tonia Novitz intervening as a discussant. Only after that, we will open the floor for Q&As. So this altogether will last, hopefully, 4 hours. We will try to be even faster because we have someone missing from the first session. A few information. As you can see, this video is recorded and at the same time is also streamed on YouTube. So I hope this will not somehow discourage you from intervening in discussion. That's not actually the purpose of it. For a good conference, I would suggest anyone else, the speakers, to shut their microphone, to keep their microphones shut, and possibly also the cameras, so that there will not be problems on the connection. So let's start this conference. Why we are here. So it's important to understand what's the point of having a conference on just a draft, on just a proposal. As you all know, on April 21st of this year, so a little bit more than 1 month ago, the European Commission presented to the public its proposal for a regulation laying down harmonized rules on artificial intelligence and amending certain union legislative acts. A previous draft was leaked some days before, but the final text was a bit different in some parts. These proposals comes as the result of a complex preparatory work by the Commission and its advising institutions, committees, and groups. The proposal was anticipated by a white paper on artificial intelligence published on the 19th of February 2020. So only after almost a year, we do have now the text that we are discussing today. So if we look at the time perspective, there has been an evident acceleration in the overall process, definitely boosted by the activism of this current European Commission and its president, von der Leyen, who announced in her political guidelines for the 2019-2024 Commission, a union that strives for more, that the Commission would put forward legislation for a coordinated European approach on the human and ethical implications of AI. The European Council and the European Parliament have also undertaken a considerable amount of work in the area of AI. The Parliament, for instance, in October 2020, adopted a number of resolutions related to AI, including on ethics, liability, and copyright. In 2021, we have had resolutions on AI in criminal matters and in education, culture, the audiovisual sector as well. The EP resolution on a framework of ethical aspects of artificial intelligence, robotics, and related technologies specifically recommended to the Commission the purpose legislative action to propose legislative action to harness the opportunities and benefits of AI, but also to ensure protections of ethical principles. How much of all of these recommendations are in the text is to be seen. But from the Commission side, at least, the promise to have EU legislation on AI fairly soon has been somehow kept. We need to verify now whether, as we say in Italy, the hasty cat makes blind kittens, which can be maybe translated into Anglo-Saxon expression, more haste, less speed. Now it's up to the European Parliament and the Council of the European Union, of course, to work on this text. And this is why it's important that we gather around the proposal and discuss it. It's part of scholars and intellectuals at large as a mission to engage with lawmaking process in order to praise the benefits, but most importantly, to flag all critical issues in order to improve the quality of the legislation, the functioning of the European Union internal market, and as far as labor law is concerned, the levels of protections of human rights at work in Europe. The proposal is a key piece in the Commission's ambitions towards a European strategies for data. But most importantly, when the regulation will be adopted, this regulation will impact dramatically on the future of Europe and its citizens for the next decades. It's a pivotal piece of legislation and must be analyzed and balanced very carefully. Now, we have leading experts today with us who will tell us more about the proposal, but let me explain a little bit more why we are here today. And most importantly, why a labor law scholar like me in a labor law community like the Labor Law Community Association is organizing this. Well, it is a matter of fact that one of the major topics in recent years in academia, but also in the public debate, is the so-called future of work. Entire careers have been built very quickly on the science of foreseeing how new technologies will change the way we work, the way we understand the work and organize it in companies, but also in trade unions and employers' associations. In this narrative, even though, of course, different voices and sometimes conflicting voices raised, there was one clear fact. There is a big correlation between technological development and labor and its regulation. The main point, besides any futurological aspect, has been for some of us dealing with the matter to understand not if, but how new technologies disrupt the world of work. Among some usual basic caveats, I want to stress some of them. There is no such a thing as technological determinism. Technology is the result of political, economic, cultural, social, and legal choices. AI and robots have been usually blamed in the large rhetoric for disrupting European labor market. But this rhetoric is likely to hide some more important factors that have disrupted European labor market. The labor market deregulation, the weakening of collective bargaining, the outsourcing of work, the relocation of manufacturing, the undermining of welfare state, and the tax avoidance by super rich and multinational corporations. So anyways, there has been a number of conferences, events, committees, books, careers on future of work and the AI. And yet, it's fascinating to acknowledge that the role of work and the position of employment and its fundamental rights in the theoretical foundation of the Commission's proposal is very limited. Please note, this is not just some disappointment from a labor law scholar who believes that there is nothing better than labor law, okay? This is a major concern related to the impact on labor law that such an approach would most likely produce, as our speaker in the second session especially will address. For instance, I will give you an example. In the recital 15, the text goes like this. Aside from the many beneficial uses of artificial intelligence, that technology can also be used and provide novel and powerful tools for manipulative, exploitative, and social control practices. Such practices are particularly harmful and should be prohibited because they contradict union values of respect for human dignity, freedom, equality, democracy, and the rule of law and the union fundamental rights, including the rights to non-discrimination, data protection and privacy, and the rights of the child. But what about employment then? When we already know that there are technologies already in place in our labor market that manipulate, exploit, and subject workers to totalizing control, then the rules regarding employment simply go on the opposite direction. As me and some colleagues discuss in our papers and articles, one of the major problems of technologies in general, but even more so with digital technologies, is that machines often do not only automate work, but they end up sometimes in automating workers, in automating their bodies, in automating their souls. The hazards of workers' dignity, privacy, and freedom is at stake, and simply the proposal does not meet any of these challenges. Rather, they create even more problems, as we will see in the second session. As my maestro told me when I was soon starting my PhD in one of our first meetings, told me, remember, and I would like to extend this to all the attendees today, remember that labor law, while limiting managerial prerogatives, at the same time, it also authorizes them. It makes them lawful. So the result is that what is regulated in the AI Act in terms of surveillance, monitoring, managing, recruiting, and firing workers is going to be accepted as a lawful practice, which will immediately raise huge conflicts with domestic jurisdictions whose labor laws have more restrictive limitations to managerial powers. One of the main problems with this structural issue is that the legal basis of the proposal is rooted on rules about internal market and not on provisions of the Charter of Fundamental Rights. Then what to do next about labor law issues in this text? Another reason for disappointment is the repeated reference in the text to an anthropocentric approach to AI. In the age of climate change and ecological crisis, we cannot accept that the environmental and ecological cause are still put in such a secondary level. Of course, there are many good points in the Commission's proposal, but some have already commented it as a missed opportunity, considering the shortfalls and loopholes that the current text presents. Just to name a few, some terms are not defined at all, such as high-risk AI systems. Sometimes the definitions are vague. Exceptions are also not precise, which opens up, of course, for large discretions to derogations. There are also evident antinomies and inconsistencies between alleged goals set forth in the explanatory memorandum and the recitals compared to the actual regulatory text. For instance, remote biometric identification are forbidden only if they are real-time and only if they are used for law enforcement purposes and only if they are used in public spaces. But our speakers will dig more on this. What is not forbidden, hence lawful, is huge in this, after this text, and often in conflict with fundamental rights acknowledged by the Charter of Fundamental Rights, as well as by the European Conventions of Human Rights and the European Social Charter, especially when it comes to work. As I said, there are many good aspects of this proposal. For instance, I believe that the extraterritoriality or the aterritoriality of the scope of application is a great point. The jurisdiction of the regulation covers providers of AI system in the EU, irrespective of where the provider is located, as well as users of AI system located within the EU and providers and users located outside of the EU, where the output produced by the system is used in the Union. So we see that the Commission has resorted to a sort of effects test, which will potentially extend the law's reach to companies without a market presence in the EU that use AI system to process data about EU citizens. Moreover, we are aware that these standards, the standards set by the AI Act, will most likely affect companies working outside the EU, being the European Union an attractive market for about 450 million people. But we are also aware of the fact that there is a big geopolitical tension about AI in the world, where the EU, of course, has to face two big competitors like the US and China, which most likely will not adopt regulations inspired by necessarily by fundamental rights and human rights. So the EU might face risks in terms of economic and political power in this worldwide battle. Yet the best way to do it, the way that really meets the AI Act ambitions to protect fundamental rights and the environment, is very seldom the easiest or the cheapest way to do it. So I would now move very quickly to present the speakers, a few words about all of them, and then we can start with the greetings from Marzia and Jorgen. Marzia is the president of the labor law community. She's a professor of labor law at the University of Brescia. Her research profile focuses on very important features of labor law, namely anti-discrimination law, where she is definitely one of the leading experts, and not only in Italy. She's also very well renowned for her huge work on establishing legal clinics. Jorge Etne is head of department of Lund University. He's a professor of EU law. His research and teaching profiles focuses inter alia on business law, EU law, competition law, and state aid law. He's also the director of the master program in European International Trade and Tax Law and the director of the Center for European Studies at Lund University. Then we move to the first panel. The first panel will be opened by Guido Smorto. He's a professor of comparative law at the University of Palermo. His research focuses on law and tech, economic analysis of law, digital markets, European private law. In particular, he's been working a lot on platform capitalism, sharing economy, and the legal implications of technologies like blockchain. He's active internationally, having strong collaboration with Fordham University School in New York and Nagoya University Graduate School in Japan. where he had courses in comparative law. After Guido, Michael Veal intervenes. Michael is a lecturer in digital rights and regulation at the Faculty of Laws at the University College in London. Michael's expertise is a perfect mix of computer science and technology law, particularly in the context of fundamental rights and advanced data analysis, including machine learning and artificial intelligence. Michael holds degrees from Maastricht University and the London School of Economics. His PhD from UCL is on the application of law and policy to the social challenges of machine learning. His publication have a big impact in academia as well outside academia. He has written reports for a variety of organizations, including Law Society of England and Wales, the Royal Society, and the British Academy, the United Nations. His works have been widely covered by the media, including the BBC, The Economist, The Guardian, the New York Times, and the New Scientist. He's also featured in parliamentary debates and been vastly cited by international regulator and governmental organizations. Then it's going to be the intervention of Rosanna Fanni. She's Associate Research Assistant at the Digital Forum Coordinator at CEPS, a leading think tank and forum for debate on UF affairs. She's also a Fulbright Schumann grantee for this actual academic year. She's an interdisciplinary researcher interested in the governance of and through technology with a focus on the EU and internal relations. She's currently working on the impact of AI on fundamental rights for the study to support an impact assessment of regulatory requirements for artificial intelligence in Europe. She's also analyzing the European AI policies in light of transatlantic and international relations as a Fulbright visiting researcher at Georgetown University and Brookings Institute, I guess where she is right now. And then we will close this first session with Frank Pasquale. Well, Frank does not really deserve any presentation. He's simply one of the most famous and eminent experts on law and AI in the world. Anyway, just a few words to thank him for accepting our invitation. He's a professor of law at the Brooklyn Law School. During his education, he was based in some of the most important law schools in Western world, Yale Law School, Oxford University, and Harvard University. Frank is an affiliate fellow at Yale's University Information Society Project and a member of the American Law Institute. He is co-editor-in-chief of the Journal of Cross-Disciplinary Research on Computational Law and a member of the Australian Research Council Centre of Excellence on Automated Decision-Making and Society. Frank is the leading expert on law of artificial intelligence, algorithms, and machine learning. His scholarship is internationally recognized. His works are featured in top law reviews. He's also advising governmental officials on cutting-edge issues in law and technology. Pasquale's book, The Black Box Society, The Secret Algorithms That Control Money and Information from 2015, and The New Laws of Robotics, Defending Human Expertise in the Age of AI from 2020, both published by Harvard University Press, are considered landmark study on AI and the law. So once again, we thank Frank for accepting our invitation. The second panel will be more focused on labor law. Indeed, we will have three distinguished labor law scholars with us. We will start with Miriam Kuhlmann, who is an assistant professor affiliated to the Institute for Austrian and European Labor Law and Society Security Law at WU Vienna. She's currently visiting researcher at Harvard University Weatherhead Center for International Affairs. Her research and teaching profile focuses on age discrimination, labor law, digitalization, and the impact of labor and social security law. Discrimination through algorithms, enforcement of labor law, impact of EU law on national labor law, among other things. Her impressive publication list counts peer-reviewed journals articles, book chapters, conference papers, and a edited relevant book on theorizing labor law, published by Hart. From this year, Miriam is also a member of the European Committee of Social Rights, this important institution of the Council of Europe. So I'm sure that she's bringing all her knowledge on this very matter in this important institution. Then we have Odd Cefaliello, I'll pronounce it in Italian, who is a researcher at the ETUI, where she started in October 2020. She has a law degree from University of Glasgow and the Université d'Auvergne in France. She's one of the experts working at EUI on the matter of occupational health and safety. On this team, she dedicated pretty much all her education at postgraduate level, so master thesis and also her PhD from Glasgow University. And then we will finish with Valerio De Stefano, who is a both ZAP research professor at the Institute for Labor Law and the Faculty of Law at the University of Leuven since 2017. Valerio comes from Bocconi University, where he got his master degree, his PhD, and the postdoctoral research as well. From 2014 to 2017, Valerio was active at the ILO as an officer, where he worked massively on non-standard employment around the world. He was visiting academic at the university, at the UCL, at Clare Hall College in Cambridge, St. Louis University, and Melbourne University. He's one of the leading voices in academia on platform work and labor law concerning algorithmic management. Valerio's impressive publication list counts articles in major specialized academic journals and also has a lot of reports which have become reference material for institutions around the world. He's the co-editor of the Dispatches session for the Comparative Labor Law and Policy Journal and the editorial advisor for the International Labor Law Review. Before opening the debate to the attendees of this conference, we will have the precious intervention from Tonia Novitz. Also in this case, I will be very short because Tonia doesn't deserve any presentation. Well, she deserves, but she doesn't need any presentation. Tonia Novitz is a professor of labor law at the University of Bristol. Her research interests encompasses the legal regulation of workers' organizations and their activities, international and EU trade, migration, protections of human rights, and most recently, the fundamental issue of sustainability. She's a graduate at the University of Canterbury, New Zealand, a Balliol College in Oxford, and then she holds fellowship at the International Institute for Labour Studies in Geneva, the European University Institute in Florence, and the University of Melbourne and Auckland. She's been working in Bristol as professor since 2008. She's currently the chair of the steering committee of the Labour Law Research Network, the UK representative on the advisory board of international lawyers assisting workers, a member of the executive committee of the Industrial Law Society, as well as vice president of the UK Institute of Employment Rights. She's an honorary member of the Whole Square Chambers, based in Bristol and in London as well. Her scientific work is by no means the most influential in current labor law scholarship. So without spending so much time again on Tonia's curriculum, I would just want to thank Tonia for accepting our invitation and engaging in such demanding challenge to discuss all the talks and all the inputs that our presenters will give us today. So I took it a little bit more time than I had to, but I will immediately give the floor to Marzia Barbera, professor in labor law, president of the labor law community. Marzia, the floor is yours.
Thank you. Good afternoon and welcome to this seminar on behalf of the labor law community. Just a few words to say why we are so glad and pleased to host this seminar together with the Department of Business Law of the University of Lund. The proposal laid down by the European Commission after a long period of preparation, which included the already mentioned white paper launched last year, and also a wide process of public consultation, forces us to address a wide issue, that is the potential risks of artificial intelligence. It is an issue to which we as our labor lawyers are particularly sensitive. The world of work has long been a place where technological tools and digitalized supervision systems have been experimented, with the result of invading the workers' privacy and controlling and disciplining their lives. We must not be afraid of artificial intelligence, but of natural stupidity. These are the words, the answer that Roberto Cingolani, a well-known physicist, academic, current minister of the Italian government, gave in an interview a few months ago when asked about the dark side of artificial intelligence. He added that the artificial intelligence, like all technologies, does not have sides. It's only a tool that, as Vincenzo already mentioned, can be used for positive or negative purposes. He also added that a user who is not aware of the risk associated with the use of a technology is dangerous. The European Commission seems keenly aware of this danger. The white paper and the proposed proposal highlight many benefits that artificial intelligence presents, but at the same time, warn of the danger associated to these new technologies and of the challenge to the European values and fundamental rights and principles that they entail. Artificial intelligence is developing fast. This is the first challenge that it poses to us. The necessity of coping with a process that has an exponential growth, where potential risks soon become real. This is particularly alarming if we consider that it's still unclear which are the most suitable regulatory tools to govern management through algorithms. To begin with, we deal with opaque decision-making systems. We don't know enough about them yet. Lack of transparency is one of the major problems posed by artificial intelligence systems. What we already know is that in the digital labor market, we find exactly the same discriminatory attitudes that characterize the traditional labor markets with regard to all discriminatory factors. Since the minds that program algorithms are not different from those that normally choose whom to hire, promote, pay the most, fire, and so on. Another thing that we know is that modern technologies are able to track the behavior of workers in several ways, and that the type of activity that employers intend to monitor influences the way artificial intelligence tools are implemented. For some time now, law has begun to culturally arm itself against these risks associated with artificial intelligence. But law is not enough. We need a cross-fertilized knowledge in which ethics, law, and philosophy intertwine to solve the questions related to technological innovation. In this regard, I think that the Code of Ethics of April 2019, drafted for the European Union by a group of experts, including, in addition to computer scientists, industrial engineers, and mathematicians, also jurists, philosophers, and ethical scholars, is an example of this cross-fertilized knowledge. Only by doing this, we will not remain trapped by the paradox of increasingly developing powerful tools at the technical level, while remaining incredibly disarmed at the cultural and regulatory level. Today, we will try to develop some of these cultural tools, analyze the artificial intelligence system used in the context of work, among other things, and discussing whether the proposed regulation will provide sufficient safeguards to counter the risks associated to them. We are very grateful to our speakers and to any of you for joining us in this conversation.
Thank you very much, Marzia. Please, Jorgen, the floor is yours.
Thank you very much, Vincenzo. So I'm Jörgen Ettner. I'm head of the Department of Business Law at Lund University, as presented earlier. And I should say that at the Department of Business Law, we have several research themes that relate to artificial intelligence. We have AI and intellectual property law, we have AI and competition law, and we have AI and tax law, and of course then AI and labor law. And we also give courses for students in AI law nowadays. So today's conference on then AI for fundamental rights at work fits very well into this research profile. So I must say that I'm very happy to co-organize this conference with the labor law community, and of course special thanks to Vincenzo and Marcia, who has really made this possible. The theme chosen for this conference is of course very topical. Artificial intelligence creates challenges to our society, not the least employment, as Vincenzo stated earlier. And it's not easy for the legislator, neither at national or European level, to keep up with this very fast development. I suppose that you will soon start to debate and also criticize the Commission proposal on the AI regulation along the lines of the subtitle to this conference, which is the easiest proposal on a European approach to AI up to it? I guess the answer will be from some of you at least that not really. However, I think it's fair to also say that this legislative proposal is anyway very welcome. And I think you agree on that. It focuses on the most important issues. And it obviously fosters an important debate, which we will have here today. I cannot say that I've been able to go through this proposal carefully myself. It contains more than 100 pages, and it covers not the easiest method to grasp. But I can see from the proposal, as also was then pointed out by Vincenzo, that the aim is to make the internal market work properly. The legal basis is Article 14 in the treaty, or the functioning of the European Union. But also that the needed harmonization to make this happen is actually about fundamental rights, mainly. And this makes the proposal not only very complex because of these very technical issues, but also highly sensitive. Sometimes legal researchers are hesitant to analyze an ongoing proposal because it is not yet valid law and it's subject to changes anyway. And I must say that I'm very glad you don't hesitate to discuss and analyze this proposal, because it's now the debate and your contributions are really needed. I'm personally convinced that the European Union will adopt an AI regulation in the near future, and it's now the research can have the most prominent impact. With that, I leave the floor, or should we say the screen nowadays, to the ones who actually have something more important to say in this matter. And I'm also sorry to say that I cannot stay for very long. So I leave over to you now, Vincenzo. Thank you very much.
Thanks, Jörgen. Thanks a lot. So now it's time to start the first session of today's conference. And the microphone goes to Guido Smorto from University of Palermo.
Thank you, Vincenzo, for inviting me, and thank you to Marcia Barbera and Jörgen Hattner for this invitation. I'm very glad to be here with you today. I share my presentation. I have to be, I am disabled now, maybe because I had to, I can't share it. So if you can try to, okay. I think I can now, okay.
Yes.
Can you see the presentation?
Yes, Guido, go ahead.
Great, thank you. So a risk-based approach to AI regulation, this is the way the proposal on artificial intelligence is usually presented. This pyramid divided into different stratified groups, grouped by risk. Also, if a risk is unacceptable, then the use of AI is prohibited. If a risk is permitted but subject to compliance with AI requirements and conformity assessment, if there's no risk or a minimal risk, then it is permitted. or if there is a transparency issue, then transparency obligations are put into place. So the logic, the way it is framed is if-then logic, sort of based on the degree of risk, sort of formal logic based on subsumption, if-then. When I was asked by Vincenzo to give this presentation, so to give a general presentation to the proposal, but also at the same time to give a view on it, I rather prefer to reframe it as a balancing of interesting. So which is the battleground of competing interests, which is based on identifying these interests, placing value on them, and weighting, comparing them. Because I think this is a way to show the proposal, what is at stake with this proposal. This is a slide taken from the European Community presentation given by officials of the European Community. And this is the conventional presentation. AI is good for citizens, for business, and for the public interest, but it creates some risk for the safety of consumers and users and fundamental rights. Here is like the vision behind look like AI as a purely technical system, which in principle is efficient and cheaper, and usually objective and neutral, that can help us to give the best decision, to make the best decision in any possible action, a way to fix social problems. That in some cases can create some risk. This is a presentation, of course, and this is an oversimplified picture, but we can find the same kind of balancing in the explanatory memorandum and all across the proposal. AI, this is taken from the very beginning of the proposal, the explanatory memorandum. AI can bring a lot of economic and social benefits across the entire spectrum of industries and social activities, but it can also bring about new risk and negative consequences. So what we need is a balanced and proportionate regulatory approach. We know that balancing is just an expression of the proportionality principle. So when we talk about balancing and proportionality, we're talking about the same thing. And what kind of approach? The minimum necessary requirement without unduly constraining or hindering or increasing the cost in a disproportionate way. So this is what the explanatory memorandum say about the kind of balancing that is proposed by the proposal. We have four kinds of balancing that are taking place here, or at least I divided for the sake of simplicity in this presentation in four different streams. The first one is the bottom part of the pyramid that says that no rules for most AI systems. This again is a slide taken from official presentation of the European Community, and the assumption is, you can see at the top of the slide, is that most AI systems are not high risk. So in this case, we can see in the green part of the slide, there's no mandatory obligation and just codes of conduct are encouraged, but no mandatory requirements are put in place. And this goes to bring us to when we talk about balancing interests, it's not just we balance interest in a vacuum, but there are some sort of empirical premises that we take into account. And here we have an empirical premises, which is most AI system will not be high risk. Is that true? Is that not true? But this is the assumption of the proposal. The other one that we can find here is that for many cases, this other category where we have transparency obligation is a category where the only duty is transparency duty, sort of bot disclosure law in very sensitive field, as an example, in emotional recognition, or in having those kind of bots that simulate human characteristic. So the question here is, are we sure we want just to put limit to, we want to put just transparency obligation and not to put limits to the possibility to simulate human characteristics, to counterfeit humanity by this bot? So this is the assumption. Emotional recognition as such is just subject to disclosure duties, no more than that. So a first category is the minimal or no risk, with no discipline, no mandatory requirement, just in some cases, disclosure rules. At the top of the pyramid, we find what theorists call overwhelming balance, which means that one interest prevails over the other and we have a total ban. Which are the fields where this total ban takes place and why? Again, a slide taken from the official presentation. In those cases, when AI contradicts EU values, in this case, the employment of EU is prohibited, like subliminal manipulation, which result in physical and psychological harm, or exploitation of vulnerable categories, general purpose scoring, social scoring, or some cases of remote biometric identification. Here, the criticism is that, I just sum up in this slide, few of the most common criticisms that have been made for this total ban is that it's very narrowly constructed. So, for example, subliminal techniques are forbidden only if they result in physical or psychological harms. But as an example, if subliminal techniques are employed to affect our behavior in voting system or in economic choices, this is not included. Social scoring only if made by public authorities. The exploitation of vulnerabilities is forbidden only for specific categories. The biometric identification, there is a massive campaign in this moment in Europe that want to ban biometric identification as such, and not just for real time, made by public authorities, made for law enforcement. And there is no reference to other uses of AI that can contradict EU values, can bring discrimination, can stigmatize groups of people. So the assumption of this proposal is that we have the most AI uses that bear no risk, a very narrow group of uses of artificial intelligence that is forbidden, and a part that I would define as definitional balance. By definitional balance, I'm talking about those balancing process where both interests are recognized. So there is no interest that override the other. And so we have a sort of balance, a striking, a balancing. And this is what the proposal defines as high risk. What is high risk in artificial intelligence? Two categories. The first one is when the artificial intelligence is embedded as a safety component of regulated product. AI employed in medical devices, cosmetics, toys, and so on. In this case, the sectoral regulation apply. But what is more interesting, according to me, are the field where a standalone AI system can be applied. You can see this list is taken from Annex 3, biometric identification, critical infrastructure, education, training, employment, essential services, law enforcement, migration, border control, democratic processes, administration of justices. Here, in all these cases, the proposal consider appropriate to delegate function in all these fields to AI and computer. So the use of artificial intelligence is the interest that prevail in this balancing and is given priority to other interests. Here you can see Article 7 is quite illustrative of the rationale of the proposal, because it says when we can amend the list of fields we have just seen in order to classify other fields as high risk. And you can see here that we have a judgment based on the intensity of interference with the interest and the degree of importance of the interest. And usually when we have such risk, great risk, and reason to justify an interference is so great, here, in these cases, balancing can easily lead to total ban. Here we don't have a total ban. Here what we have is procedural requirements for high-risk AI. So just to sum up what I said about the high-risk AI, which is the core part of the proposal, AI can be used in all the fields that we have seen before under some requirement. These requirements are establishing and implementing a risk management process based on training, validation, and testing of data, documentation, transparency, and robustness, accuracy, and cybersecurity, and human oversight. But we don't have time to go into the details of Article 14, but if we look at Article 14, we will see that the human oversight is not the idea of complementing AI with human intelligence, is more like a sort of replacement plus control model. We can use AI, and if something goes wrong, then the human oversight can do something on this regard. So we have a procedural balancing, the possibility of applying artificial intelligence in all that field if we respect these requirements. But what I find more interesting, the fourth element and the final element of this balancing strategy adopted by the European Community, which is the ad hoc balancing. Ad hoc balancing is the balancing we do in a case-to-case basis. It's the small decision that shape the way AI will be developed, more than the general definition, is more in the single cases that the way the AI will develop in the European Community will take place. And there are some aspects of this ad hoc balance which I consider of extreme importance here. Look at these three rules. Article 9 on risk management system, on the quality management system, and on the post-market monitoring system, that you all use very indefinite criteria to make the balance. If the residual risks are acceptable, if the implementation of the quality management system is proportionate to the size of the organization, if the post-market monitoring system is proportionate to the nature of the risk. So what we have here is that the ad hoc balancing, which decide whether a single specific use of artificial intelligence in high-risk field is forbidden or not, depends on extremely vague criteria, and it is based on a self-assessment by those who are, by the providers themselves, so that by the controlled ones. So the way the ad hoc balancing is made by the same provider, with the only exception of biometric identification system, for which a third-party conformity assessment it is provided. So we have a model where most AI uses are considered not to bring any risk, a very narrow group of uses that are considered to be forbidden, and high-risk users in the most sensitive field where there is an ad hoc balancing based on vague criteria, on an indefinite criteria, and delegated to the provider of the service with small exception. I'm going to conclude, Vincenzo, because I know I'm just please. The last minute to show you to declaration that we can find in the press release by Margaret Vestager and Thierry Breton that make pretty clear that the balancing they had in mind was the balancing between the European tradition and the global competition, especially with China and US on artificial intelligence. The thing is here, and I conclude with this idea, is that this minimalistic approach adopted by the European Union, together with the high margin of appreciation that the balancing process put in place and the delegation of this balancing to the controlled ones, create a sort of balancing made in a black box. And the risk and the challenge we have here in front of us is avoid the risk of impairing the current level of protection of values and rights in the European Union. Thank you.
Thanks a lot, Guido, for introducing in medias res, how we say in Latin. And thanks also for giving us this perspective of balances and unbalances. Now it's time for Michael Wiel and his presentation. Thanks, Michael.
Great, thanks everyone, and thanks Guido for that. That's a really fantastic introduction, and that touches upon some of the themes I want to develop as well. So I think they work really well together. I want to talk a little bit in detail about select areas of the regulation and trying to make some connections with that and current AI practice to indicate some of the challenges that exist. So I've looked at this because this is the product safety paradigm that I want to focus on in particular, and I think there's quite a lot of people read the AI regulation to begin with, particularly those who hadn't been familiar with broader union law in the past and may have thought it sort of exists ab initio, it came out of nowhere, and really there's a lot of common themes in there. So I want to focus on three main areas that I want to go over today. One is the nature of responsibility in the context of using AI as a service, which is really, really heavy market driver. Also is very important for thinking about workplace surveillance and worker management here as well. The second aspect, which is linked to all of these, is the nature of the regulation as focusing on off-label usage and what that means and who defines what's on the label. And then lastly, touch and elaborate a bit more on some of the enforcement challenges that are specific from having adopted a product safety paradigm. So people will remember this, or some of you will remember this. The point here is not that you have an operating system. The point here is that this is software that's in a box. And this software, you could go to a shop and you would buy it, and when you bought this software, it would be yours. You could install it and you could reinstall it from this CD, and you obviously can't edit really what's on a CD. It's a static image in time. This is when many people think about buying an AI system, if they haven't actually been familiar with the market, they might think that you're purchasing a piece of software that you can then deploy in your organization or so on. And many people who are writing about this, scholars, their experience of software is sort of rooted still, I think, in when they were using it in this period of time. However, software is not developed like this anymore. Software has two main components to the way that software is developed and deployed. Firstly, it's developed in a way that's constantly updated. You don't just buy something in a box, in a shrink-wrapped software box anymore. You get access to a product which is changing and updating the whole time, just like your computer updates regularly. And that was after the time of Windows 95. You'd get a few service packs that you might buy as additional CDs and add on. But now, of course, your computer is constantly updating, to many people's frustration. However, another aspect is that software is also delivered as a service. So there's two aspects I want to highlight here. This is the Compass system. It's the system that has received quite a lot of scrutiny in the US over recidivism and parole scores, and it was clearly in the Commission's mind when they drafted Annex 3, of the regulation, listing parole and recidivism as one of the areas which would need a conformity assessment. So an interesting thing about this is there's two parts of this product that you can kind of see here that's relevant. The first part is it's delivered online. You see it inside a web browser, and that web browser, it says Web Compass Net. It doesn't come from the premises of the organization that's using it, so it's being delivered as a service. They don't have access to software in a box. They have access to an AI model that's very far away. The second aspect of this is that which you can't see so easily from this photo, is that all of these elements about criminal activity and so on relate to a model that's trained with certain data. And this model has been trained with data from a certain context. And the context of this, actually, if you look at Compass's own, Northpoint, the company that makes it, their own discussion is they say, look, we can actually help you choose which data your system is trained on. But it's data they have. So the idea is they are providing everything. So the Compass did the first move. They said, we deliver software remotely. We're delivering it as a service. We're not giving it to you like Windows 95 so you can use. But the second move says, well, but we have some data sets. So if you are in a particularly, if you're in a city with high rates of drug crime, maybe we have a sort of data set that's maybe more calibrated towards what we think you might need in that context, or so on. And they decide, with guidance from Northpoint, which groups they want to calibrate their model against. So Northpoint still provides that. Now, this is what's also changed. We've seen Windows 95, we lost that. We've gone into software as a service, but we still have this idea of an organization in the background. The vendor has a big say in what's going on. However, this is not how it works anymore. This is a small video from Google, and you'll see
Cloud AutoML Vision lets businesses and developers with limited machine learning expertise train custom vision models for their own use cases. Developers can upload their own labeled or unlabeled dataset, train and manage their models, and use those models directly from the cloud to make predictions.
So this is Google's business strategy for cloud services and AI. Google provides, in this case, a very high quality sort of baseline algorithm, machine learning system that's good at detecting people or things or objects and images or themes, or it's good at analyzing text in many different languages and picking out what's going on, or it's good at classifying people or classifying objects or 3D objects, good at even driving a car, for example. All of these things starting to be delivered as a baseline product to say we've built great foundations, the world's best foundations for, say, machine vision. On top of that, providers upload their own data sets into these systems and specify it to their workplace. That might be uploading data sets of the emails your employees send with their productivity scores or their productivity levels in some regard. It might be uploading pictures of certain products that you sell with their actual names or labels. The idea is you specify this model to your needs, but they give you the strong baseline, but they are selling a very fungible, generic system which can be tailored to an individual use case. And this is being called AI as a service. So what they're doing here, they offer functionality that is defined by a business user, and that business user takes that prediction model. They say, okay, I need some image classification, or I need some video classification, or sound classification, or text analysis. And they say, I need it in my system. I need it inside a thing I'm going to do inside my organization. So I will work with Google. They have a really good baseline generic thing that works across all sectors, all purposes. And I'm going to specify this with some data that I have and start to engage with them. And they will provide me this software as a service. Effectively, I tend to upload a question to it and it will give me the answer. And that's called an API. So this kind of question answer system keeps the model in Google's physical hands, even though that model is specified to the business user, but they've tailored it for that context. That's very different from software as a service. So software as a service is like when you see Office 365 or Microsoft Word. A whole system has been deployed, and Microsoft have designed this whole overarching system your organization can subscribe to, and they create the whole package. Whereas this is just functionality, which often will be a small building block of something that's configured in-house. So it might be a small building block of a bespoke workplace surveillance system designed by an employer, And so I just want to analyze images or analyze CCTV data in a certain way. So I'm going to make an image recognition model without any code at all. So Google is selling this in a way that it's very easy for business users to create machine learning models without being programming experts and specify them to their need. They're very keen, these organizations, to responsibilize business users under data protection law at least. They argue that they're processors, they're not controllers, they're users of the controllers. So just like somebody storing your files doesn't have a decisive say over what's done with those files, and just like you don't go, if your health service that might be running systems on Amazon has user's data, sells it to an inappropriate organization, you don't go to Amazon to litigate, you go to the health service because they're a data controller, and Amazon say they're just the data processor. In this case, service providers of AI as a service are keen to be considered just as data processors. Now, that's not always going to be accurate. Even the Information Commissioner's Office says that, but so does a recent paper by Jennifer Codman-Jatzing at Cambridge, which is a very good read. But it's worth noting there's this general attitude towards let's lower the liability on us, a regulatory arbitrage, move it away. So this is a pattern that we see continuously. Now, this is something that applies to the AI Act as well. So let's consider in this case a business user that wishes to use AI in a way that could be considered prohibited under Title II, which is, as Guido said, is basically two types of systems that roughly map onto manipulation, but with a harm requirement. Social scoring is another one, on biometric systems with certain exceptions. Or a business user wishes to use AI that's in a sector defined in Annex 3. So these are these systems that are beyond integrating into a medical device, these particular sectors like recruitment systems or so on. But they dislike the requirements in Title 3, or they find them very onerous, so they're planning to break the law a little bit. So imagine as a business user, and we're thinking about how this would pan out for them in this relationship of AI as a service. Well, firstly, we had to think about what's the liability and responsibility of this AI as a service provider, like Google, compared to this business user. So we think these are powerful users, remember? So Google here is claiming to know how to set up the system. They're trying to make it super easy for the business user. Just click and you're done. Upload your data and you're done, and here's a product. Meant to be a very, very easy workflow that they claim will democratize AI. Well, in this case, it's very unlikely that Google will fall under Title II in what they're providing, no matter what they're providing, because systems must be used in order to distort behavior, and they must cause harm that can be anticipated. It's very hard to imagine that a general purpose system, if Google provides a general purpose base layer for image recognition or text recognition, while it's quite clear that image recognition as a technology has the ability, or text recognition, to distort behavior, or to cause physical and psychological harm if it's configured in a way that is problematic. It's very unlikely that Google will be aware of that or want to make themselves aware in any way. They are going to be claiming they're providing a tool without knowledge of its detailed use, because they're just providing simple access to an API that's had a bit of tweaking with some extra data that's provided, which Google may not even understand or be able to interpret what that data means, because they will blind themselves to what that means. They'll deliberately not ask questions. And there's no obligation here to ask for a provider of general purpose AI to ask questions to discover whether a downstream system is used to distort behavior. And if there was, you might ask questions such as, well, Microsoft Word is also involved in committing war crimes. People type documents to order deaths of people. When does this downstream level stop of software users and providers? So there's kind of questions about what that looks like. What about Title III? That's the high-risk regime where you've got these different sectors or purposes for use, and then you have a conformity assessment process that resembles product safety. So here, insofar as these provide a general service, processing generic data, it's also unlikely that it will be considered to be intended to be used in any of these sectors. So when Google sells this product as we provide general image or text recognition or analysis tools, could be Amazon or Microsoft who may also provide these, then they're not going to be intending them for certain sectors. So as an end user, as a business user, I can take these tools and put them into my own in-house software that is doing something like building recruitment systems, or determining productivity scores from emails, or configure them in all sorts of ways that would fall under those Annex 3 requirements, but wouldn't capture the organization that was the highest capacity, that was actually selling and making money from these APIs. And as I said, the product safety regime in general, which this is based off, does not place obligations on vendors to ensure products are not used illegally. And we've actually seen, of course, there's a lot of history of use requirements in European law, but chainsaw safety law doesn't try to stop people murdering with chainsaws or place responsibility on vendors if they go and do so, given these are dual-use technologies. And it's always a problem with dual-use technologies. Specifically,
Michael,
yeah.
You have roughly 2 minutes.
Yeah, I've got the timer, it's okay.
Yep.
Specifically in Article 43.4, we also see here that there's a kind of exemption for AI systems that have been modified to even undergo a new conformity assessment, which would exempt Google, in this case, even if you were claiming they had some responsibility. So this would have to be overcome as well. Because systems that continue to learn after being placed in the market will not constitute substantial modifications and require further conformity assessment. But does the user then have responsibility, this end user business? Well, they are putting it into service under their own name, but as I said, they're intentionally inexperienced. And so the AI as a service provider leaves them unable to have that real close experience. And furthermore, if they're using it for anything else other than the biometric recognition under Title 3 in Annex 3, then they only have to, as Guido said, put it in a process of internal control, which differ with organization size. So very low capacity organizations configuring things that Google give them also have very limited obligations as users under this law. Now, the interesting zone that probably will get lobbied out is such users would have requirements if they were using this system for, say, recruitment, to register it in the database of Article 60. So in that case, if we actually see Amazon build their own system in-house, for example, to do recruitment of their own employees or workplace management, they might have an obligation, even if they don't sell this, to register it under Article 60. And I expect that companies are trying to lobby that out already. So I want to then just touch upon this area as well. The idea here, if you are a business user, right, if you're a user of this business and you only have the obligations to follow the label of the manufacturer, they say you need to put in human oversight according to our instruction manual. Well, then you look for the provider with the most lax instructions. If you're a provider wanting those kind of lax instructions, you don't even need to search for a lax notification body to get that regulation, because those bodies, you just have to find a body that's willing to take a risk with internal controls and not be regulated. And if you're using AI as a service or developing it fully in-house, you only have to rely on the idea that a market surveillance authority who are set up for product safety will not proactively investigate your organization. Where they do not even know you're using AI, to knock on your door and ask them, are you using AI? And this is because in the whole regime, this is sort of where I'm finishing off. In the whole regime, the AI regulation takes a regime that is designed for manufacturers and extends it with only a single article, 63(1)(a), to users as well, users of technology. And it actually doesn't play very well. There's no mechanism to complain against these regulatory bodies, for an affected community to complain or to ask them to investigate. There's not even an obligation for them to listen to unsolicited complaints of any kind. There's not even a mechanism to raise substantiated concerns, and there is in some other EU law, like the EU Timber Act regulation. Sorry, EU Timber regulation. Everything's an act now, right? There's also capacity questions. These are organizations that have never had to deal with users. They've dealt with what's visible on a market. So suddenly they're being asked, market surveillance authorities, to look at what users are doing. That's just new to them completely. So the questions I want to end with are, how does a market surveillance authority ever become aware of a prohibited use by a user, particularly in these AI as a service situations? Very difficult. And are these organizations actually capable of enforcing regulation in this context, given that it's such a new area to them? They've never gone into use. So hopefully I've outlined some of the potential loopholes in this regulation so far that people can look into themselves, and looking forward to the rest of the talks. Thanks.
Thanks, Michael, for this wonderful talk. I mean, we are starting now touch with our hands the loopholes and the limitations of this proposal. Now I move immediately the floor to Rosanna. And yes, please, you should be able to share the screen. Exactly.
Hi, do you hear me and do you see my
Yes,
slides?
it's all good. It's all good, Rosanna.
Just 1 second. Okay, yeah, thank you so much for inviting me, and also thanks for the two previous presenters, very insightful keynotes. For my presentation, actually, I'm going to take a few steps back. I'm not directly speaking, I will not directly speak about the regulatory proposal, but actually how did we ended up here? So how did the entire proposal came into being? Yeah, so just a few words about myself. As already mentioned, I'm Associate Research Assistant and Digital Forum Coordinator at the Center for European Policy Studies in Brussels. And currently, as mentioned, I'm a Fulbright visiting scholar at the Brookings Institution, not at Georgetown, unfortunately. And this didn't work out because of the pandemic, but I'm at Brookings and looking more at the international perspectives of AI policy. And this is also really important to mention. I'm not a legal scholar, so please, my apologies if I do misuse some of the kind of legal terms. I'm more looking at the policy side. So that is also going to be my main focus of the presentation. So what I'm going to speak about today is the study to support an impact assessment of regulatory requirements for AI in Europe, or brief, the AI impact assessment study that we conducted at CEST. And also I'm trying to post the link in the chat, if I can go back to the chat somehow. Okay, it won't let me do that, so I'll post the link later on. So I'm briefly outlining what we did in the study and what we looked at and what kind of results we found. Namely, there's strong evidence of AI impacting all EU fundamental rights. And this came at a point when the white paper was not yet published. So this was really one of the main building blocks, I guess, also for the white paper and also for the subsequent regulation. And then I'm also looking at the policy layers that are starting to emerge since the publication of the white paper, and also now over the past years. So the local, regional, national, supranational, international AI policy, and what that means for regulators in Europe right now. Okay, so first, AI fundamental rights in the EU. Actually, why has AI become such a concern for policy professionals, not only for legal scholars, but especially also for policymakers in Europe? Well, as we all know, there are unaddressed risks today, but in terms of virtually all fundamental human rights. But more importantly, and this is also something that we found in our study, as I would say is one of the main outcomes, there will be more incremental risks for society at large. And so what at CEPS has happened, basically, my supervisor, Andrea Renda, was also part of the high-level expert group. And so what this AI high-level expert group basically concluded is that a more thorough assessment of the fundamental rights, violations, or threats in Europe is needed, especially also when we look at safety and security. And so CEPS basically started this study. Here's the link to the study, but as I said, I will post in the chat later on. The study ran from February 2020 to April 2021 and was published alongside the regulatory proposal and consists of 4 chapters, mapping the impact of AI on EU fundamental human rights, safety and security. And very importantly to mention is that the study was really kind of a multi-stakeholder process. So first, we concluded several workshops with Commission representatives, and then we subsequently involved, for the different chapters that I'm going to present right now, we subsequently involved the relevant stakeholders. So we collaborate a lot with civil society organizations. Then for the second part and the first part, especially SMEs and SME representatives and representatives bodies. Then we also had a chapter on standards where we involved standard experts, and then obviously also people from academia. And so I'm going to briefly show you or explain to you the building blocks of the study, let's say. The first section is dedicated to a comprehensive literature overview of existing evidence of the risks and harms generated by AI for fundamental rights as well as safety and security. So yeah, we basically in this literature review, we mapped the existing evidence of use cases of AI that violated, for example, rights to non-discrimination or that exacerbated biases. We looked at human agency, the loss or the decreasing, the decrease of human agency and autonomy, such as AI introducing dark patterns, filter bubbles, and hyper-nudging practices. And then the next chapter deals with the freedom of expression and information that is also severely impacted by AI systems, and the right to free elections, data protection and the right to respect for private and family life. Then the chapter on biometric identification and facial recognition technology, where we found big evidence for a more restrictive basically regulation, as the scientific evidence was and still at the time is very not really coherent or flawed, as some would say. So we reviewed a lot of literature on this topic. Then automated decision making in governments was also one of the parts that we really wanted to focus on, as we found it increasingly important for the European Commission to focus the regulation also on that. Access to justice and a fair trial, including risk prediction, risk modeling, and social scoring, obviously was also part of that. Then the use of AI in courts and law firm, transparency, accountability, migration policy. So you see it's a wide variety of topics basically, but we were really impressed how much literature is out there that's actually documenting already fundamental rights violations in the EU context. And so the next chapter that we analyzed was, actually I also forgot to mention that this section also contains an analysis of risks for safety and security, that we divided in two categories: material risk and immaterial risk. And then we further deployed a taxonomy that was already part of another literature review on AI safety and security. So that also contributed to several parts of the impact assessment on AI on fundamental human rights. So the second chapter is an overview over international AI policy and emerging regulatory frameworks. So we did a comparative overview over the national experiences from not only the EU, but especially also other countries, for example, Australia, Canada, the US, the UK, Japan, Singapore, and with a specific emphasis on risk governance. And this is also a literature review, and I'll come back on this topic in my second part of the presentation. The third section of our study is the evaluation of the public consultation on the European Commission AI white paper. So the public consultation was launched, I think, along with the white paper publication, and basically any stakeholder could submit answer or submit something to feedback to the Commission, and this we also analyzed in the study. So we had in total over 6,000 free text responses and 408 position papers. And there, really interesting was to see that really most of the submissions looked at the definition of high risk. So that may be obvious for many of us, but it was really something that many stakeholders highlighted. So Many respondents believed that the definition of high risk in the white paper was unclear or would need more improvement, and also many responses find that the binary classification was too simplified, and the outcome is, as we also see now in the regulatory proposal, that the Commission introduced 4 stages of risk governance. And then also what I found interesting was that more position papers generally agreed with the white paper's approach to regulatory requirements for high-risk AI than those who disagree. So there was generally more of response to regulate AI and high-risk AI in specific, which could be surprising because the consultation was open to everyone. Subsequently, also business stakeholders contributed. So we had a submission from Google, from Facebook, from Amazon, and such. But obviously, as I said, also a lot of civil society organizations. And then what I also found interesting is that human oversight was the most frequently mentioned requirement that should be taken into account more by the regulatory requirements. So a lot of stakeholders really emphasized that human oversight would be one of their main concerns that the regulatory proposal should approach or tackle. Followed by training data and record keeping, and information provision. And at least 24% of stakeholders specifically mentioned a remote biometric identification. So that is also quite significant and shows you something about, I guess, the importance of the regulation focusing on that. And then maybe one last point also on that. Most stakeholders did not address actually the institutional governance of AI. So many people didn't really focus on how regulatory policy should work out in practice. But of those that did address this issue, 10% were in favor of a new EU-level institutions and or even 6 favoring a new creation of a new agency. An AI agency, and 4% were in favor of a less formalized EU committee or a board. And this is also what we can read in the regulatory proposal, is that the European Commission introduced an AI board, but and this is also one of the main takeaways from our study, is that AI is such a moving target, basically, that it is at the moment not yet clear for the Commission how to set this up. And that, the extent to which this AI board will operate or will focus on specific use cases, on specific violations of AI, on fundamental rights, amongst others, is also important, because it's not yet clear what some of the more incremental risks for society will be. And so the Commission will adapt as it basically goes. Very briefly, Section 4 is an assessment of the costs of complying with AI regulation, which was also quite a challenge, because at the time, obviously, in 2020, there was not yet a regulatory proposal out there. So we were challenged, let's say, by this task, but I think we did it quite well. Which you can all read in the study. I won't go into detail. And what's next, obviously, the proposal came out, and now it's up to the Parliament and the Council to further refine this text. So very briefly, maybe summarizing some evidence of AI threatening fundamental human rights, which is the annex of the study. It's Annex 1. So you'll find a long table in the end where we really try to map as many fundamental rights violations as possible. And some that I found quite relevant for this presentation was, for example, recruitment processes. So robo-recruiting. So, for example, automated predictive hiring systems are most often biased and also violating EU rights. And the tools are often developed, tested, and first used on non-EU markets, which makes it even more challenging, I guess, for EU policymakers to respond to that, obviously by an extraterritorial approach. And the second evidence that we found was surveillance at work, that there were a lot of documented cases for example, on mechanisms that would automate performance reviews or presumed inferences, which is maybe even more critical on employee performance monitoring, team dynamics, and the job satisfaction of employees. You can find all those references at the end of the study. And now very briefly finishing up with the international perspective. I know I'm quite late, but it's just my last slide, basically. The emerging AI policy initiatives and fora. This is also what I'm looking at more right now, as the impact assessment study is already finished and published. So in 2017, actually, well before the European Commission, Canada adopted as a first country a national AI strategy with principles, but these principles, most importantly, only focus on governmental use of AI, which is obviously a very important topic, but they don't address AI for society at large. And by now, some 60 countries, I think, have AI policies, but most of them really don't deal with it as the European Commission proposal does. So that is quite, I guess, a landmark also on an international perspective, and remains to be seen how it plays out. Exactly. So in our study, we also analyzed in section 2, as I mentioned, a few countries' strategies and how they differ between each other. As I said, also most are either voluntary or focused just on very specific uses of AI. And then in addition, what is emerging as a picture is that a lot of organizations focus on AI and the use thereof, or collaboration around the use or the regulation. So, for example, the OECD is quite involved. The GPI is an institution by the G7 that looks at how to increase cooperation on AI. The ITU has an IA for Good Summit already since, I think, 3 years. Then standard developing organizations are also very involved in that topic, obviously, with each their own interests, let's say. Then AI is more increasingly incorporated in trade agreements. And then just yesterday, I think I read something about the new US-EU Trade and Technology Council, which is probably also becoming more important as the US also looks more at regulating AI in their own, let's say, ways. So more sectorially and also more on a national, like state level. So the highly complex institutional landscape poses really difficulties, I think, to aligning on AI regulation, and also will make it more difficult, I guess, for the EU to find their own voice and to really enforce the legislation on an international level. Some open questions that we currently look at is obviously the Global South is not really included in any of these debates, on very few of them. So that's going to be a challenge, I think, for the next years. And then the extraterritorial scope of the AI legislation is going to be seen. And then international dispute resolution along of the invalidation of the privacy shield, for example, something that could also pose some significant challenge to the EU's AI proposal. And with that, I'm sorry for the slide overlap. This is the summary, and thank you so much for listening. And I'm happy to engage further with anyone.
Thanks, Rosanna, for this more policy note on the regulation. And please do share the link to the full report so we can consider that. So now it's the time to give the floor to Frank Pasquale. Frank, I see you. I think, Christina, we need to make Frank co-host in order for him to share his slides. And Frank, as soon as you're ready, please go ahead. Thanks.
Sure, thank you. And I see I've been made a co-host, so I'm just going to try to find my presentation. I've got a bit of a busy screen right now. Let me just see if I can find this. 1 sec. Sorry. And first of all, thanks so much to everyone for just some really, really excellent presentations. I just have found the presentations today have really clarified a lot. I'm very sorry. I had to step away from my mouse to a smaller computer because of the configuration of the Wi-Fi, and now I can't seem to get to. No, oh, here we go. I see. Sorry. Just trying to find this one.
Technology
here we
is
go.
taking
I've got
revenge.
it now. Sorry about that.
That's great.
So here's the PowerPoint, because I do have quite a few citations in it, and so I didn't want to actually just present without the PowerPoint. So here's thanks so much to Vincenzo and to the organizers for this opportunity. What I'm trying to do here is to provide, going back to the old the jurist Oliver Wendell Holmes, looking at the law as the bad man does. That was sort of his classic description of part of his approach to legal realism, and to considering law as simply a prediction of what judges and decision makers would do. And so what I was inspired to do here, given that you've got such a wealth of expertise on European law from the other presenters, is to give a sense of the types of struggles that have already emerged in the US in law and technology regulation, and how these struggles and these types of strategies of the regulated entities might be useful in considering the future path of if this is ultimately adopted, of the deployment and enforcement of the AI regulation. And of course, on some level, I don't really need to go too deeply into this, because I think that the GDPR has already been a very good example of some of the deep problems that occur with respect to advancing law and technology regulation. But I thought that, given how much I've been thinking about AI regulation, and some work I've been doing with Gian-Claudio Maglieri on different approaches, I would have something useful to add here. So one of the things that I wanted to sort of discuss today is the persistence of labor law concerns, right? There are classic concerns in the labor law that have been, part of the motivating force for the law for decades. I was just reading Julia Stone's classic book on law and social science, which he published in 1962, sort of recapitulating some of his work from the 1940s. And even then, these concerns about Taylorism and micromanagement were certainly there. There have been, ever since the development of the Equal Employment Opportunity Commission, concerns about biased or unfair hiring practices in the US. And of course, anxiety about automation and imitation of movements of workers to automate without compensation, right? And so I think that if you were to translate or transpose some of these concerns into the modern AI context, there's a worry about laundering of dirty data via complex machine learning and AI, right? There's the thought that even if we don't reach the alienation concern, which is part of my agenda in the second wave of algorithmic accountability, there's still a concern about the laundering of data, or data that would ordinarily lead to suspect a process being thrown into the black box of AI and ML, and therefore and in that way leading to very troubling outcomes. And with respect to Taylorism and micromanagement, this is supercharged by constant surveillance by sensors that are never distracted, right? At least the boss, a human boss, could be distracted at some point, or the person is only human. With respect to these new sensors, they can be on 24/7, and there can be data extraction without compensation, even more efficiently with AI and sensor networks. Now, moving on, the idea that I think is really critical in considering all of the great points that have been made so far is a risk of regulatory arbitrage. What are the strategies of regulatory arbitrage that the regulated community will deploy to undermine the effect of AI regulation? And I'm going to get into later on in the talk an article I wrote in 2019 called Six Horsemen of Irresponsibility, sort of drawing on the four horsemen concept of the apocalypse. And I think there's a lot of worry there. But I also wanted to give an example just from recent US labor policy that I think is instructive in terms of how you can anticipate how the regulated community will try to undermine the law here. And this example is from US occupational licensing policy. So there's been a lot of resistance to occupational licensing in the US, the idea being that this is inefficient or unfair, et cetera. And the way in which I think that the deregulationists have gone after this has been first strategic litigation to find edge cases, right? So they don't challenge the occupational licensing of plumbers, right? Because everyone has a sense that like you probably want to have a plumber to have a license to fix, what's going on in the apartment above you or something like that. Rather, they find sort of these edge cases, right? Edge cases that are seem really ridiculous on their face, like the licensing to braid hair or licensing to be a flower arranger in Louisiana in the US. And so that strategic litigation creates a narrative about occupational licensing in general. The idea is that if you strategically find the edge case, that can help you build up public sentiment against regulation, thinking of it as ridiculous or something like that, right? And that clearly was the strategy behind Brexit, the idea that the EU was regulating the curvature of bananas or something. You create both real and unreal sort of narratives about the general structure of regulation by looking at the edge cases. And I'm going to look at some edge cases today that I think could be used to develop regulatory arbitrage strategies. The other is strategic funding of economic research. I put that in scare quotes to promote supposedly universal benefits of deregulation, and strategic alliances with sympathetic decision makers, right? So all of these are strategies that I've seen and I wrote about with Sandeep Vahasan, who's now the legal director at the Open Markets Institute in the US, with respect to deregulating labor law in the US, right? And I'm going to go through in the next slides, how these types of strategies might be at the hand in Europe over time. And so we have to ask, where might similar opportunities emerge for employers who wish to undermine labor protections from AI? Well, this is a chart that, again, we've already seen a version of this from Professor Smorto, right, and from and others, is that the idea of the 4 levels of risk in unregulation of AI. And this is a slide that I've draw from a presentation that Gian Claudio Maglieri and I have done for our research on trying to flip the presumption and trying to say that, in fact, that we should presume a lot of the AI is unlawful before it is even deployed. But the European approach is very different, right? You have an unacceptable risk category, a high risk category, limited risk and minimal risk. And of course, the devil is in the details in the high risk category, right? That's where a lot of what we are concerned about, particularly assessment of workers, is going to happen. And then the question becomes, how easy is it to sort of get around, especially the self-regulatory dimensions of regulation there? And I'm particularly inspired there by Ari Ezra-Waldman's work to interview the people that are actually in charge of putting into place compliance with regulation, right? And a lot of times what we find is that while firms may talk a good game and they may be really publicly in favor of AI regulation, when the rubber hits the road and it actually has to be coded into the relevant product, there's a lot of resistance. So how might that occur? How might that be developed with respect to AI regulation and labor? Well, let's start with some ideas about surveillance, and how essentially surveillance can give enormous advantages to employers vis-a-vis workers, given existing asymmetries of information, right? So ubiquitous data collection gives many large firms a massive advantage in terms of anticipating and short-circuiting labor organizing, or even finding people who they may want to demote or get rid of in terms of if they're worried about them. And wages may be dynamically set by platforms taking advantage of fissured workplaces, to use David Weil's term. And surveillance can advance the classic speed up of work. That was the classic concern of Braverman and others, and about labor being speeded up because of technological interventions. And I think the recent work by Gavin Mueller, Breaking Things at Work, is a really interesting and good revision of the classic labor history there about what was going on when workers resisted that. But what I want to also really emphasize here, and what I think is the core of erosion of labor protection over time is that consumers may demand more surveillance of workers as well, right? And this is a theme in my book, New Laws of Robotics, is that when you have not only management able to appeal to the value of surveillance and AI and ML in various situations, be they health, education, labor, consumption, et cetera. When you can do that and you can add in a consumer demand, that can become something of a juggernaut against protections for labor, right? So one thing that I would mention here is that, consider how far, at least in the US, the digitization of credit could go, or if I'm sorry, in labor, I should say labor there instead of credit. If labor could go, if employers lobby for full data access, that can lead to a panoptic bargain, a higher wage for more surveillance, right? And you might get even groups of workers saying, we want more surveillance if we can get higher wages if we are surveilled. There's also increasing pressure to watch and monitor workers who are called upon to watch and monitor AI. And I'll get into that in the next slides about sort of the problem of AI in the field, in the wild, and the problems of photomation, FAUX, or false automation, and Potemkin automation that Astra Taylor and Jathan Sadowski have talked about. All of this could be, under current economic frameworks, very efficient, and also under some legal frameworks, consented to by workers. But that consent can lead to equilibria that are invasive, predatory, and subordinating. So we have to watch out for that. Right. Here's an example that I think is really interesting, is to think about, AI and surveillance in a new form of work that is itself about AI. There was an autonomous vehicle crash in Arizona a few years ago of an Uber car that was a self-driving one, but it had a guardian driver at the wheel to watch out for, say, pedestrians or others in the road. It turned out that the guardian driver did not prevent this car from actually running over someone. Right. And the question that I sort of ask about that particular situation is, what types of AI-enabled surveillance of the driver would be permitted under current law? Remember, here we have this sort of nested automation scenario where the car itself is autonomous. It's sort of driving with AI, but it has a human in the loop watching it. And then the idea is, do we want to allow, or do companies want to allow and to promote AI that would watch, say, the eye movements of the driver to make sure the driver's eyes are always on the road, in the same way that my eyes are kind of constantly on the Zoom camera now to give the impression of eye contact, right? This is the sort of thing that I think is like a really deep and difficult question. And there's I think that there's a question in terms of how far would this be seen as high risk to the employee who's being watched? And then how do we balance that against the employee being watched as someone who's trying to actually be watching over a high-risk AI system, that being the autonomous vehicle, right? Another example there is, should the guardian driver be continually reported on and surveilled? And are there any limits to such forms of responsibilization, right? If we were to think about privacy-related constraints in nursing home camera rules, in the healthcare context, there will be a lot of pressure to, say, use new forms of surveillance to make sure that the healthcare workers are doing their best or are following protocols, right? There might be very complicated protocols in the wake of something like COVID or other infectious diseases. Employers may well be bringing in new forms of surveillance in order to make sure that their employees are actually abiding by these protocols. So these are things, issues that have been very presciently addressed by Levy, Kilgore, and Berridge in their article, Regulating Privacy in the Public-Private Space. A lot of this is about sort of anticipating these types of very complex problems and enabling forms of ongoing conversation, co-regulation, negotiating regulation among representatives of labor and of capital in these types of settings. Now, coming back to the EU approach, one of the things that Jean-Claudio Magliari and I have settled on as we've sort of gone through the proposed EU regulation is some problems that we've already seen foreshadowed in other presentations today, including limited scope on manipulation, limited view on vulnerability, too static and not flexible, limited risk AI solutions that are ineffective and too generic, and no individual rights and no mandatory participatory design, right? These are deep problems within the current draft of the regulation, and they really must be addressed in order to deal with the complexity and to anticipate the complexity of what I've just discussed. But from a US perspective, or I should say, and from a US perspective, there are even more problems, right? And so the further problems that I've called the horsemen of irresponsibility, the first I'd say is trade secrecy, right? I wanted to look very closely at this regulation, and I have not, done a full due diligence of it yet, but I want to look very closely at what are the carve-outs for trade secrecy. If someone says that, well, the way that I do this is secret, and if you want to investigate further, or if you want further reporting on what we're doing, that would violate the trade secrets of our organization. If we're to look at some of the overall critiques of the European Union as a whole, I mean, all of the critiques that come out of studies of its sort of neoliberal orientations, a lot of these critiques focus particularly on what Quinn Slobodian calls the encasement of the market, of the single market, as opposed to the embedding of the market, right? So there's an encasement of the market with respect to certain rules guarding the prerogatives of property and capital, as opposed to a Polanyian, Karl Polanyi style embedding of the market. And I think that's something that's really worrisome, especially with respect to trade secrecy and how I've seen that misused in other contexts. Also, I worry about unfunded regulatory mandates. Speaking about, again, I know this talk has been very meta and very recursive, but this is yet another layer of recursion here. When I looked at the expected personnel effects in the regulation, it appears that the drafters of the regulation said to member states that they expect that 1 to 25 full-time employees would be necessary to add to implement the regulation. Now, I was not able to see whether the European Commission or others were arranging for the funding of the member states to provide these persons, or whether that was just going to be more, say, unfunded labor on the back of existing persons in the nationally competent authorities. But that's a huge concern as well, right? If we look at the history of the Federal Trade Commission in the US, it's a history of increasing ineffectiveness, primarily because the agency is sort of seen as this dumping ground for cutting edge concerns. So if we continually overload national level regulators with more and more things to do without commensurate funding of the persons able to actually carry out the work, then it's going to be, there's just going to be problematic, and at the worst case scenario, and this is from an article I wrote in 2017 about the US Federal Trade Commission, is that the commission itself was so sort of underfunded and uninterested in the problems imposed by very large corporations and aggregations of capital, that it started enforcing against labor. It started actually going after labor. It started going after Uber drivers as opposed to Uber itself. Okay, and so this is a problem that I think is really important, is to think about these unfunded regulatory mandates. Another is preemption. And I really don't know the legal background there in Europe as opposed to the US, but I just bring it up because in the US, often federal law will preempt stronger state law, and I think there was some concern about the GDPR doing that to some member states' privacy regulations and data protection regulations. Ongoing pushes for deregulation, exculpatory clauses. What's the interaction between this and contract, right? To what extent will contract law, will we just see basically those who should be regulated by this just putting out a contract and saying, please consent to waive your rights under this, or to waive your rights to penalties, or to waive whatever it might be, and that, again, may not be nearly as much of a concern in Europe as in the US, but I just bring it up. And then finally, free expression opportunism. Are you going to see those who market these systems say things like, well, when my system gives a person a score of 72 out of 100 as with respect to their reliability, that's my opinion. And if you say I can't give that type of score, you're violating my freedom of expression, right? Again, this doctrine has not gone nearly so far in Europe, but I think that there is a real concern that it might, the further the regulation goes, the higher the danger gets. So I want to finally just end by saying that, preserving a tort regulation balance may be very key here. AI development is excited to be applauded, but it will likely only be fair and just if the legal system, as informed by standards of care, informed by expert regulation, permits individual rights of action and encourages rights of petition. And this is something I've been working on as well. I'll be publishing a piece soon about the context of licensing uses of big data. Malglary and I are working on this in the EU context. But I think that ultimately, to really get a grip on some of this stuff, we may well need to flip the presumption and to say that in many of these high-risk contexts, rather than having such a self-regulatory model or an ex post facto regulatory model, that there needs to be ex ante review and approval of the relevant AI in order to prevent it from going into effect, to avoid all of the different problems of regulatory arbitrage and resistance that I've already mentioned. So with that, thanks very much.
Thank you, Frank. That was amazing, and amazingly in time. You've just finished when my alarm was starting. So I really enjoyed your presentation, giving us this idea of how irresponsible companies might somehow undermine the regulation. And it was really interesting to see that this kind of responsibility is not only about the companies. We can have responsible consumers as well as the responsible enforcement institutions. So thanks a lot, Frank, for this inspiring presentation. Now we have it's almost 4 o'clock in Europe, in Central Europe, and we have now roughly 15 minutes, pretty much, or 20 minutes to have a debate. I see that Michael Veal was somehow intervening on your presentation, Frank. So I'll take the chance to, unless there is already someone from the people attending the conference, if you have questions to pose to each other in the panel first, and then we might try to attract, in the meantime, questions from the audience. So I don't know, Michael, if you want to turn your intervention into a question or a comment to Frank's presentation.
I think it's, that particular intervention was just a side note, I think. I think Frank's points are very prescient. Part I didn't really kind of get to talk in detail in the presentation is really about the issue we have with repurposing a product safety regime into this other regime. And we find, the whole of the EU Act has been, bits and pieces have been taken like magpies. So the prohibitions come from the Unfair Commercial Practices Directive, largely in the way that the language is framed. The product safety, Title 3 comes from the product safety regime, the idea of notified bodies and so on, which isn't even taken as seriously as it is in some other areas. And I think we've got a really interesting challenge here, because I think as Frank was talking about, we might need to think more broadly about how this might not be an applicable regulatory structure. Just like data protection was a sort of sui generis regulatory structure that emerged in the 60s and 70s and then matured, we really may need to do this deep thinking here. And it's quite clear that this regulation has not gone through a very creative process. It has been a bit of people searching for tools that they can repurpose and then cobble together and glue between, and then hope it does the job. And I don't know if that's really ambitious enough. So I do wonder then, also thinking in this kind of transatlantic way, one big question for, I think, this group of scholars is to say, if cobbling together like existing product safety plus commercial practices plus some other things on the fringes doesn't work, do we have to do a broader thinking of what that looks like? And what kind of process, how do we actually get there? Because at the moment, the Commission has the right of initiation. It comes from quite a dry, non-creative place in a way, where permanent staffers are unwilling to put their careers on the line by suggesting something mad, and the political system inside the Commission does cramp down the possibilities. It's not like kind of the US Senate, where you get random ideas just thrown around and just people just draft things and submit it. So maybe we do need to think about that. And I would like to pose to everybody, do you think this is a good foundation, or are we going down the wrong road in path dependency, and we actually need to push back and say, this is the wrong place to start. If you want to get over here, you want to go over there, you wouldn't start from here.
Thanks, Michael. I think it's a marvelous way to engage with the rest of the panel. Who wants to have a word on this? I see Guido. I don't know about Guido. I can't see Guido's Morto anymore, but we have Frank. Yes, please, Frank.
Yeah, I don't want to, since I've just finished, I didn't want to hog the spotlight, but I will say briefly that, like, I do think that, Michael, that's a really good question. And it's sort of like the question then becomes, is there, I really, your point about both product safety, I think and this is where I think that there is a bit of a problem, which is that perhaps they are trying to both ensure safety in looking at things like, okay, there's going to be AI in medical devices, right? And that's certainly a proper way of doing so. But they're trying to shoehorn in some concerns about fundamental rights and discrimination into that type of regime. So can we, and this is something where, I mean, I have to admit, like, my own work may have helped promote this type of this type of path dependency, because I recently wrote this piece that was on sort of tort and regulation, sort of saying, well, if we have machine learning diagnostic software that, say, is discriminatory, that doesn't have enough, doesn't represent relevant populations well enough, that is almost like, to the extent that's a tort, we could sort of like make that viable for tort. And so perhaps the problem is that, like, our notions of accountability are coming too much from, like, liability regimes or other things like that. The other thing that I would also argue, that I would say is like a problem that we've seen in the US is, in the US, the Consumer Financial Safety Bureau, the Consumer Financial Protection Bureau, the CFPB, was based on the Consumer Product Safety Commission. So it was a direct effort to use in finance regulation a model from product regulation. And this was in Elizabeth Warren's classic article in Democracy in 2007. It ultimately got taken up in the 2010 Dodd-Frank law. And the problem with the model, I think, is that it was too, in the realm of financial regulation, there's too much disagreement about what ultimately constitutes a good outcome, right? So Republicans in the US think that the key freedom for people with, let's say, credit and lending is that you should be able to go to any store anywhere and say, agree to 100%, 300%, 500% interest rate. That's your freedom. And if you want a contract for that, that's freedom. And that, like, the Bureau has nothing to do with that. Whereas, like, the Democrats would say, no, it should be capped at 36% a year. That's all that people should have to pay in interest, is 36% a year. And if you don't have, whereas, like, I think with products, there's general agreement that we don't want a scooter to blow up underneath you, or a toaster to blow up or cause a fire in your house. So I think the problem probably comes down to, is the product regime. It's deceptively simple, because we can all agree on what makes for a dangerous product, or almost everyone can. But there may be some very deep divides about what makes for dangerous AI. And then that's what leads to the need for participatory design and ongoing feedback that makes it a much harder problem than the product problem. I don't know.
Thanks, Pasquale. Rosanna or Guido, do you want to say?
Just a few words on some aspects that have been touched. The first one, I think the proposal will be soon complemented by another proposal on product liability. The European Commission in many occasions said it will present a new proposal on product safety, product liability. And in the first documents, the emphasis was very much on AI and IoT, on Internet of Things and artificial intelligence. In the last documents, the shift was to the change in the value chain, so the involvement of platforms as an intermediary in the value chain and the liability. There is a strange thing in Europe. I think in the United States, in between 2015 to 2020, was some 100 cases involving Amazon for product liability. There's no such thing in Europe. The outcome in US, Frank Pasquale may say much more than me on this regard, but the outcome, as far as I know, was very much affected by jurisdiction. So the Airy doctrine. So there was federal courts applying state law, and they took a very conservative attitude on this regard. So most of the outcome on these cases was in favor of Amazon. Now something is changing, but I don't know how much. The other two aspects I want to mention is that the emphasis on self-regulation that the European Union is taking in all these issues, not only in artificial intelligence, but also, for example, on the responsibility of intermediaries and online platforms, especially those providing, enabling the provision of underlying services. And I don't think this self-regulation, so the idea that these intermediaries are sort of marketplace able to regulate themselves because they have both the interest and the tools to do that. The reality is they are not collaborating very much with the authorities to implement the rules. There are just few exceptions on that regard. And the other point I want to mention is about trade secrets. For example, the regulation that passed in 2019 on the protection of business user vis-a-vis online platform provides just some transparency requirement, but then these transparency requirements are curbed by trade secrets. It's written just in a small part of the legislation, but it's a big limit to the possibility to enforce transparency, saying that there is trade secret as to counterbalance the duty to disclose.
Thanks, Guido. Rosanna, do you want to intervene?
Yes, I would also have a few scattered comments, basically, and maybe on what Guido said and also what already was mentioned by Frank. The kind of the surveillance of those that are going to be subject of this regulatory proposal is definitely a challenge for the Commission, and I think we also already realized that when we were writing our study. So we interviewed several market authorities, market surveillance authorities, standard setting organizations that might also come into play. And no one, I have to say, was really well prepared for that, as AI, as we all, mentioned it already, is such a new and kind of ever-evolving system, is also really well presented by Michael. So that, I think, is going to be a huge issue, and the Commission obviously will need to go and learn basically from the experiences made. Sorry. And then what I also was thinking when listening to your presentations is actually, where does the issue come from? And I think the elephant in the room is not China this time, but it's actually more the US and those huge multinationals that are deploying AI in their very market advantage. And obviously, me again from the policy perspective, I can just say that the collaboration and political, let's say, ties with the US are on a critical level, especially after Trump, and now the change in the administration is obviously marking a change and departure, basically, also from the previous administration, and that the EU would like to engage more, and so putting a huge conflict up in regulating AI, also regulating privacy, is a sensitive matter at the moment, at this very point in time. And actually, we've already seen a bit of a change in the US administration is in regard to their approach to AI. So the new Office for AI has been established, for example. There were several state legislations that were issues. So, for example, in New Jersey, or the CCPA in California is also introducing another law for regulating facial recognition, for example. So I think the main point is really that the EU and the US politically are set to cooperate much more. And so this, I think, is going to be really interesting to observe how that plays out in cooperating on AI legislation oversight. And I think actually now the mood is more set on cooperating on research projects, for example, and not so much looking at, the harms that we need. But I think this is potentially a critical point that should not be overlooked, especially at the moment. And then also finally, on the EU's regulatory patchwork, as I always like to call it, obviously, I didn't mention it, but the Digital Markets Act, the Digital Service Act also, especially with liability, are points that will need to be, assessed in light with the AI regulation, and also the Data Governance Act, for example, also data storage in the cloud, which is, one of the main essentials for building a successful AI model. So that is, I think, also going to remain to be seen. So yeah, just a couple of scattered points here.
Thank you, Rosanna. Now there is someone from the audience raising his hand. Before I give him the floor, I just wanted to say a few words on Michael's point. I think that, well, in the most optimistic view, we could have seen a total different foundation from the Commission on regulating AI. Like, for instance, it happens when it comes to pharmaceutical products. So you have to somehow test and prove that there is no danger before actually being authorized to use pharmaceutical products in the market. So that might be, too enthusiastic or too optimistic, but I see that we are completely on the opposite side of that. So that's also kind of concerning in itself. So Rudiger Kraus, please open up your microphone.
Okay, yeah, thank you very much. First of all, I have to say I'm a German law professor and currently a member of a group of experts who tries to give some recommendations for a future possible Employee Data Protection Act in Germany. And of course, in our deliberations, we also touch AI. It's not, we focus not only on that point, of course, but we touch that. And we face two problems. One problem is, in our impression, that a lot of employers do not understand the logic which stands behind in AI, and I've got it from the presentation of Michael, and all presentations were very, very impressive. That in particular, if AI is delivered as a service, it's continuously changing, and this means that the algorithm apparently change every week or so. And this means that it is also very complicated for employers to know what they do when they employ and they use that technique within their firms. And the question is for us how to regulate this. It's one option could be, and I want to know if you can agree with that, or you have some ideas on that, to come to, let's say, certification procedures to say some products have to be certificated by, let's say, public authorities or groups of experts, by employee side, trade unions, and so on, and of course IT experts, and to understand what's behind that, and does it affect in particular the interests of workers in a invasive way? Is it only a good dream, or do you think that could be a way to cope with that? That would be interesting for me. Yeah, thanks.
Thanks, Rudiger. I think Michael has already
come in on that to begin with. So yeah, of course, the AI Act has aspects of certification in it, and I expect the Parliament will try and extend the requirement for notified bodies to get involved to other parts of Annex 3, to extend that certification requirement, which itself is very lax, doesn't have employee involvement or anything like that, as Frank illustrated. But I think the overarching question, the interesting thing, the idea that algorithms are constantly changing is part of a very misleading narrative that's been spun by tech firms, such as we have the data, we have the power over time. In the end, there's a lot of kind of buzzwords and phrases that get picked up by legislators. They think they're tackling the real core of the issue, but they're really not. I think work, particularly by Julie Cohen, is very good as an antidote to some of this, because she points out that what you have to think about are platforms orchestrating the world and orchestrating, privately ordering the way in which these services are delivered. So here we can see a parallel between the advertising sector, I think. And this is why I wanted to mention AI as a service and what I really think the problem is. When we see Google's role in advertising, for example, Google likes to sit in the middle, orchestrate it, make sure that the most vulnerable little other companies are doing the most heinously illegal thing, put them in a system which incentivizes them to do the most illegal thing, and sit in the middle of it and extract value without doing the most clearly illegal thing themselves. So they want to orchestrate illegality, but not really want to do it explicitly. Just create a system where there are market incentives and other incentives for illegality, which is profit making, to occur, like in ad tech, and then reap the rewards. AI as a service is the similar thing. Sell your generalist system, just allow it to be configurable in many different illegal ways, but not by you. Deliberately blind yourself to that happening. Sell these services to organizations that themselves will carry out that illegality. But make sure they exist in a system where enforcement of them is practically impossible. So it will take a very long time for anyone to get to grips with this. As Frank says, if we're getting like 25 extra people in a competent or market surveillance authority, the ICO in the UK can't regulate, and it's got hundreds of people. So we're operating in that world now. And why AI as a service is all about, we just provide the building blocks. You configure them in the illegal manner, and we just take the money. So this is what's happening, and this is where you see them as a platform and their intermediation power. And I think that's where we have to keep our focus on. And the AI Act doesn't deal with that, because if you certify the lowest capacity person in the system. At the very end, it becomes whack-a-mole, when really you have to focus on the orchestrating power, which the AI Act doesn't do even slightly, because it's based on a regime where we want to stop unsafe things from entering a market. Therefore, we do want to stop nodes. We don't care if people are publishing academic papers that might indicate that you shouldn't wear a hard hat on a construction site. That's not the product safety regime's interest. They care about the actual physical delivery or the sale of those items.
Thank you, Michael. Anyone else?
I would just say that I think that these are great points, Michael, and I would also say that I agree with you on the point about certification. I think that, and I think that the real aim here should be to vet these products, vet these services before they're put into place. And even if they were to change over time, that there be documentation of those changes that could itself be sort of analyzed later. And this is something that I think that the Food and Drug Administration in the US is wrestling with respect to medical devices that have AI and machine learning in them. And I think that there's some models there. So I'm happy to, I can send a proposal that I've written up that will be published, I hope, within the next month or so on in that vein to flip the presumption. Because part of the goal here, I think, should be to slow down the adoption of these systems and to give us an opportunity to make sure that they're legal. Because the ultimate issue here is that many of the systems themselves are making legal determinations themselves, right? In that sense, and to that extent, like they are, we need to vet them before they're put into place, rather than allowing them to just be put into place willy-nilly, because there just isn't enough personnel to surveil them. And beyond that, even if there were, trade secrecy protections may keep existing regulators from surveilling them, from understanding what's going on.
I think Guido wanted to add also something.
No, I was making just a very general comment regarding how in this period the rules we are shaping, we are giving, shape the way the organization changed there. And we can make a parallel with, again, with product liability, where if we keep going with sort of no responsibility for intermediaries, we run the risk that the most risky products are sold by third-party vendors, and this organization, the intermediaries plus vendors, reserve for themselves the sale of the less risky products. So again, we run this, according to what Michael said, again, even here, we run the same risk of organizing the activity in a way that shelter a company like Google from responsibility, giving the responsibility to smaller firms.
It's more particular than actually. I would say there's Google wants to place itself in a position where they are structurally unable to certify the thing that you care about because they are too upstream. Yet they are the only people who have the resources or capabilities who could do that certification. So there's this. That's kind of this interesting zone that they put themselves in, where a certification scheme will fail, but they don't want to be. So this is why they won't go and sell a recidivism system. They won't go and sell a hiring scoring system or anything like that, because that would make them targets for regulators. Instead, they want to let regulation slip off them by producing general purpose technologies. It's the usual thing in STS of dual use technologies, right? So it comes back to a lot of these questions.
Yeah.
Thanks. It's 4:20 here in Europe. So I would say that we can consider this first session finished. So we can have 10 minutes to, get out from our seats and take a cup of coffee and then reconvene at 4:30. But before doing so, let me extend my warmest thanks to Guido, to Michael, to Rosanna, and to Frank for such a wonderful panel of interesting presentations. I think we have increased tremendously the knowledge of this draft already in slightly 2 hours. And I think that this is just a starting point for a lot of work to do from the academic side, as well as from the inside of the persons engaging in societal problems. So thanks again. Of course, feel free to stay with us for the second session. It was a great pleasure to have you here. So thanks a lot, and we will reconvene in 10 minutes roughly at 4:30. See you. Yes, Miriam, I was just about to get in touch with you. So it's 4:30 here in Central Europe. So it's time for us to move towards our second session, which has 3 presenters, 3 labor law scholars, because the second session, of course, focuses much more on labor law issues. We start with this second session with Miriam Kuhlmann, who is going to talk about discrimination and privacy in the perspective of this new proposal from the Commission. Miriam, the floor is yours.
Thanks, Vincenzo. I'm going to share my screen now. Let me just see. Okay. So I hope it's visible now to all of you. Thanks for this excellent seminar on this proposal. I've learned so much from the first session. So Vincenzo asked me to focus on aspects of discrimination and privacy in the context of this new proposal. So that's what I'm going to do. And also I wanted to emphasize, of course, what all speakers already indicated before, technology is here to stay, right? So also within the employment context, we will see more use of technology over the coming years. We might be a little bit slower compared to the United States, but still also Europe is progressing in this respect. Given that I've been asked to focus on discrimination, we all know that AI systems have the potential and do discriminate and bias based on criteria, sometimes protected criteria, sometimes not, sometimes based on proxies, related kind of criteria. Sometimes it's the result of the data that is used. If the input data is biased, then the output data is most likely to be biased as well. It can be a system design problem, but also the complex interactions of the two. I'm not going into the details of that because I think that many of you already know the risks involved when using AI in the context of work relationships. Moving to the next slide, just as a kind of summary, or summary, AI or systems of AI used in employment relationships usually are systems of profiling. So they automate processing of personal data used because the employee wants to know the skills of the candidates that apply for a job, or so this is a kind of profiling based on the data that is submitted or not always submitted. That is a kind of risk. So, but such kind of profiling results in social sorting and sorting of people according or along the lines of criteria defined by mostly the employing company. And of course, the interaction with the kind of software or systems of AI they're using. So what does this new proposal say, and how far is it relevant for the purpose of discrimination and also privacy? Although the two are also linked, of course, as well here. So what is the primary aim of this proposal? Labor lawyers or labor scholars or employment scholars, they know that when you read that the legal basis is the functioning of the internal market, the first thing that comes to mind is Viking and Laval. What about labor rights? What about its relation to the proper functioning of the internal market as a legal basis? Frank already mentioned the notion of preemption. So what does this regulation actually do? I'll have a slide on that or say something about it in a minute. But it is about the function of the internal market. It's not about social rights. It's not about non-discrimination or fundamental rights, although there is this interaction, of course. The main aim of this proposal is to make the AI systems safe and compliant with the law. At least that's something we will find in the preliminary notes. And also it aims to minimize the risk of algorithmic discrimination. Similar words we will find in the white paper as well. So many elements come back here as well. But one thing, of course, is to harmonize the rules of the games for the internal market. So the core aim is not employment, it's not fundamental rights here. But if you move but what does this actually do? Like, what is the harmonization level here? Do member states actually have a possibility to offer better regulation here? The answer is most likely not, because it is an internal market regulation. The question, however, is if you compare the legal basis, Article 114 of the Treaty on Function of the European Union with Article 153 of the treaty, on labor and social policy measures, there you will always find the possibility for member states to offer better protection. And then the question, of course, is how do the two interact with each other? Also because there are linkages, important linkages between the GDPR, which is also a regulation, and we have important linkages with fundamental rights, such as the right to non-discrimination, which is also regulated at European level. So it's kind of unclear how that all will interact, and I have no clear answer for that. But I seriously hope that the right to not to be discriminated and the right to data privacy are seriously considered in this context. But all comes with some caveat, of course. But let us have a look at a little bit more like the definitions. Lawyers always look at definitions. So what is an AI system and what does it mean in the context of discrimination and work relationships more generally? So an AI system is a system that is developed with one or more techniques and approaches listed in Annex 1, which can, for a given set of human-defined objectives, generate outputs such as content, predictions, recommendations, or decisions influencing the environments they interact with. And you see below that that the techniques and approaches that are mentioned in the annex our machine learning approaches, which include inter alia supervised, unsupervised, and reinforcement learning algorithms. There are additional techniques and approaches mentioned as well, but these are the most familiar ones, I guess. So we see that it's a very broad definition. And we see, if you think of software or AI systems, to use the language of this regulation, are used in employment context for hiring, for promotion decisions, or even for dismissal decisions. You see that there is a strong link here. And we see also a strong link in the Annex 3.4, because the systems that are used in the context of recruitment or selection, as well as promotion, etc., they're considered high risk. So we see in a separate document in an annex particular reference and a summary of the employment context to which the AI Act will apply. But an interesting question is, if you look at this very wide definition of an AI system, then you see that there are some questions. For instance, isn't an HR system, a system used by human resources, covered, that is used for the recruitment of individuals, that is able to sort CVs along specified criteria, and comes with a list of candidates sorted along an invitation for interview, a long list, a candidate, or a rejecting. I think this kind of CV parsing system would be covered by the notion recommendation, because it can make recommendations based on predefined criteria. And what about an AI, a human resource system covered, following which a report is made based on certain criteria, such as the number of employees that have been on sick leave in the period between 2015 and 2020, combined with performance indicators such as the number of clients that he or she has acquired and the average working hours over a year. This would be covered by the notion content, because a report creates content and it perhaps also makes predictions or recommendations, right? So we see that it's a very wide definition, and according to that kind of definition, many AI systems that are currently being used, and I have a slide here, this is just on recruitment systems, right? So we have many more AI systems in the world that are being used in the market, but many systems would be covered by this regulation, if it is adopted in the way it is phrased now. We've seen this pyramid. I will just focus on the circled one, the high risk, because all kinds of AI systems that I've mentioned before that are used in the employment context, whether it's a pre-contractual phase, a contractual phase, or the post-contractual phase, the dismissal aspects, all these kinds of phases are covered by this high risk category. And for this, and the interesting thing is, because there's discussion, of course, what is a high risk? And I think Frank suggested, or Michael, to invert the pyramid and to see it from a different perspective. But a high risk system is a system which has an impact on the future career prospects and livelihoods of these persons. That's mentioned in recital 36. So the Commission considers the impact an AI system has on the future career of someone, or his or her livelihood. One explanation, I think, is of course plausible for this, is that within the European Union, there is this policy requirement formulated towards the member states, and ultimately to us as EU citizens living within and working within the EU, that all those aged between 20 and 64 are required to work as far and as much as possible. And because we all need to work, we are all required to have a job, we have to apply for a job, we have to earn our income, etc. It's a whole system that's running here behind the scene, you might say. So all AI systems referred to in Annex 3 are high risk. And if you look at the explanatory memorandum, the classification as high risk does not only depend on the function performed by the AI system, but also on the specific purpose and the modalities for which that system has been used. And what we find also in the explanatory memorandum, or in the recital, is that AI systems should not pose unacceptable risks. It's not defined what that means. It should be limited, or the high risk should be limited to those AI systems that have a significant harmful impact on the fundamental rights of persons, which includes the right to non-discrimination and the right to data protection, and a limitation that will minimize potential restrictions to international trade. So again, here we see the importance of trade within the European Union, but also beyond the European Union, because we've seen that the scope of this regulation is very broad, and it's kind of, as Eno Bradford calls it, it creates kind of Brussels effect, like the GDPR. Anyone who wants to enter the European market in some way has to abide by the rules of this regulation. So the fact that an AI system has an adverse impact on fundamental rights protected by the EU Charter of Fundamental Rights is particularly relevant when classifying a system as a high risk. And what is interesting, if you look further in Article 7, I think Guido mentioned this already, you see that there is a reference or a possibility for the European Commission also to use Article 7 as a means to offer more rules or more specifications for Annex 3 high-risk AI systems, especially where the risk is equivalent to or greater than the risk or harm or adverse impact imposed by the high-risk system already referred to in Annex 3. So in any case, whether we have the same risk or even a higher risk, the European Commission can offer more specific rules on that. At the same time, if you look further in Article 7, it offers a legal basis for bias monitoring, detection and correction in relation to these AI systems. So providers, irrespective of where they're established, of course, they may process special categories of personal data referred to in Article 9, if that is, if the aim of that processing is to address or to monitor the biases, to detect them and correct them. So here again, we see an explicit reference to the GDPR. There's no explicit reference in the provisions of this regulation to non-discrimination. It's just the general reference EU law. So you have to interpret it yourself.
Miriam, you have a couple of minutes to repeat,
yes,
please.
I'm coming to my final slide, but thanks for reminding. So this is just a brief overview, and I'll just highlight a few aspects of the requirements that go with the high-risk AI systems. The first question is, and Michael already dealt with who is the provider and who is the user, and the question is who is liable or responsible for what? This is an important question because if you think you have been discriminated and you want to make a case and go to court and substantiate with facts that it has to be likely that you have been discriminated, if you find out at all, then of course, from a non-discrimination perspective, the most important question is, whom can I turn to? Mostly it's the employer, but here it's not always clear to me, and I think this regulation needs more clarity in this regard, who is responsible for what, and wouldn't the worker need to go to the user and the provider of the system? These are very important open questions, according to my opinion. But what we see here is that the provider itself has to undertake a conformity assessment with EU law. So the provider has to make sure that the AI system it is putting on the market is compliant with EU non-discrimination data protection law. However, Michael already indicated if they're using just the AI system, which is trained on their own data, and they are kind of selling the AI service or the AI system to a user, for instance, who can use his or her own data, then it becomes very blurry here. And it is an internal control, so there's no external party checking this here. So you have to rely on what the provider is telling you. Let me just see on my notes. I think I'll leave it. Okay, and a last point, and then I'll really finish with regard to the user about the input data. It's the first circle text on the right side. This obligation or requirement is only applicable where the user has really control over the data. So also here we see that there are some limitations that need further attention, and hopefully through discussion in the European Parliament, things will clear up. So we'll stop here. Thank you very much. And I'm very curious about the other presenters. So thank you.
Thanks a lot, Miriam. So if Miriam had the task to somehow introduce the challenges, the evident challenges that algorithmic management puts on privacy and anti-discrimination rules, now it's, of course, the time to address the second most evident problem, health and safety at work. And for this, we have Odd Cefaliello from ETUI. Odd, the floor is yours.
Yes, can you all hear me?
We can hear you. Well, we can hear you, yes, and we can see your presentation as well.
Wait,
the audio
yeah.
is not
just again,
perfect.
I have a little technical thingy, and then I resolve that, and I can start. Yes, so I will speak loudly so you can hear me properly. Is it better like that?
Yes.
Yes. Perfect. So thank you. Wait. Yes, good afternoon, everyone. It is a real pleasure for me to, be here today and to have the opportunity to contribute to this debate. And I would like to thank the organizer for inviting me. With the intention to respect the time that I have been allocated with, I won't provide any details about the background of the AI Act proposal because that's been done brilliantly previously. Instead, I wanted to start with 3 sentences that caught my attention when I read the proposal for the first time. So the fact that the proposal is based on the EU values and fundamental rights and should be human-centric, so AI is used in a way which is safe, sounds good. Like it actually seems really promising, but very broad, which makes sense considering that the scope of this future act will be for everyone and is not limited to workplace consideration. Therefore, I wanted to give a narrower scope to make it more fit for the level of debate, and considering that that people are workers and workers are people and employers have businesses, workplace are part of society, and OSH law is part of the law, and social fundamental rights are fundamental rights. Thus, a targeted version of these sentences could read as the proposal is based on EU values and fundamental rights and aim to give workers and other users the confidence to embrace AI-based solutions while encouraging employers to employers develop them. AI should be a tool for workers and be force for good in workplace with ultimate aim and increasing well-being. Rules for AI available in the union market or otherwise affecting workers in the union should therefore be worker-centric so that workers can trust that the technology is used in a way that is safe and compliant with occupational health and safety law, including the respect of fundamental social rights. Here we talk. Here, I feel now comfortable to start a discussion about the impact of AI on OSH and workers' health and safety. So with my presentation today, I would like to focus especially on the last part and raise concerns and questions about how the AI Act actually interplay and maybe overlap with existing OSH directives that we have at the EU law. And in particular, I would like to focus on the main framework directive, which is the Directive 89/391 EEC. But before diving into the details of the provisions of the AI Act proposal, I would like to provide a bit more context about health and safety. And basically, there is two aspects to health and safety. There is first the technical aspect of it with work equipment, traditionally uses of machineries, for example. So yeah, machineries or exposure like or equipment, work equipment in general. And the other side is more the managerial aspect with the work organization and how, when the way that the employer is organizing work, how it is impacting workers' health. And both of these aspects is actually impacted or influenced by the use of AI, and I will illustrate that. So for the technical aspect, we can say that this is the cases where workers are using AI or working alongside AI. So it's the case of collaborative robots or cobots, where we can have collaboration or responsive cooperation and this kind of things, right? On the managerial aspect, this is the cases, we have talked a lot about it, of employer using AI in the management of the workers. So when, for example, some workers have their shift allocated automatically based on previous performance or preset data. And to answer, well, many reasons, but in a way to address this development and this new reality, the Commission has actually proposed or published two proposals on the same day. One is the proposal for a regulation on machinery production, which is actually a revision of an existing directive, which is the machinery directive, Directive 2006/42/EC, which was now part of the new legal framework. And on the other side, there is the AI Act, where they deal with the managerial aspect with the actually algorithmic management software that we have talked already about in Annex 2.4. The thing is, these two should be read together because they refer to each other. So to give you an example, in the draft for the revision of the machinery directive, it said that the conformity assessment, which is mentioned in the AI Act, is delegated to the machinery regulation when the AI is embedded into a machine. So this phenomenon and processes is delegated in these cases. In the same time, in the AI Act, it said, it refers to the machinery directive and said that this machinery regulation, sorry, it's not the regulation now, should fully reflect the approach of AI and the AI Act. So once again, what I want to say is we need to read both of them together. And also, which is important, is the fact that these two proposals have been the result of the work from DG GROW, which is targeting or aiming at technical harmonization. But there is another side of the coin of the market harmonization coin, which is the social harmonization, which is the competence of DG employment. And here we already have some, well, corporates and some directive applicable, especially in health and safety, with the main one being the framework directive. But just to give you an illustration on what is the social echo or the social harmonization echo of this technical one, the machinery production can be linked, I think, with the directive on work equipment, but also the directive on personal protective equipment. Similarly, the AI Act will at some point overlap or should be understood with the directive on working time and the framework maybe agreement on stress, stressing that these two, once again, are connected. And what I'm going to do today is to focus on AI Act, but still try to work on this overlap and connection, interconnection and interplay between the technical harmonization of the AI Act and the framework directive. So focusing on employer using AI in the management of workers. So, whoops, sorry, I have a problem with, yes. So once again, both apply, and I will raise three main points in my presentation. The first one is that in both cases, how we have said before, there is the question of the risk management. But how these two rationale of risk management actually echo each other, one in the AI Act and one in the framework directive. Also in the AI Act, we talk about providers, which are the developers of the AI software that have responsibilities toward the users, understood as natural or legal person using an AI system under its authority. And sometimes they also have obligation or responsibility in the way they use it. And meanwhile, in the framework directive, the two main actors are the employer, which is any natural or legal person who has an employment relationship with the worker and has a responsibility for the undertaking and or establishment, and they have obligation toward the worker. But in my understanding, even if the word user and employer is different, and in these two acts there is different set of obligation, in the reality at the workplace, this is the same person. The employer under Framework Directive Act, Framework Directive is the user under the AI Act. So I wanted to see how the existing obligation will interfere with this new obligation under the AI Act. And also my last point will be, let's go back at the workers, because as you can see, they are really far from the AI Act, but still in my eyes, they are the end users. And I know it's not technically correct, but what I mean here is that they are the ones who are going to be impacted by the usage of this algorithmic management software by the employer. They are going to be the ones who are going to feel it on a daily basis, right? So my question is, how do they fit in the picture? What can be their role, their function, and how can they sometimes benefit indirectly from certain provisions from the AI Act? So in terms of the risk management, don't worry, it won't be a karaoke one. I just want the point here is to echo and underline each part of it that they can, once again, be connected to each other. And which is interesting in both cases, if you see the part highlighted here, the risk management is supposed to be a dynamic process. So under the AI Act, you can see that shall consist of a continuous risk management, continuous the entire life cycle of the AI system. In the meantime, in the framework directive, the employer need to assess the risk that, there are at the workplace, and they need to reassess it every time there is a change of circumstances. So my question is because we said that sometimes AI can evolve a bit, at which point the evolution a bit or the adjustment of the AI change enough to trigger a new risk assessment from the employer, and how does it change how it is impacting the workers? It's an open question. I'm just wondering here, right? Similarly, in terms of the scope of the risk evaluated under the AI Act, it seems to me that the risks that should be evaluated are the current risk, but also the future risk. And there is also the risk of the use of the software, but also the potential misuse. Or foreseeable misuse that we can discuss the meaning here. But the scope is quite large. And on the other side, the framework directive said that the employer should evaluate the risk altogether that cannot be avoided. And my question here is, shall we transfer that? So when the employer is supposed to assess the risk that this software are going to represent for the workers, shall we evaluate all the risks that the provider has to evaluate as well? Like the present, the future, the normal use and the potential misuse. So this is once again an open question. And the last point is about the elimination or reduction of the risk under the AI Act. And there is the same idea under the framework directive of replacing the dangerous by the non-dangerous. So if I remember well, under the AI Act, you call it, implementation of mitigation and control measures. In the framework directive, you call it principle of prevention. But once again, just saying that there might be a background for overlap here and connection. So also perhaps to say that I'm wondering how these two are going to interplay. So to which extent once again, when the employer has an obligation to assess the risk, is he going to take into consideration the risk management or the evaluation of the risk done by the provider previously before the software has been put on the market? But also, and why not, raising the question of to which extent the provider should consult or cooperate with employers and all workers' representatives when the main aim and purpose of the software is to be applicable to the workplaces, which raises a bit the question of who is going to be a part of this conformity assessment bodies, the national bodies, right? Is there a place for the reality of the work here? Once again, open question. Then in the previous slide, I compared the same rationale to two different people. So it was the risk management from the provider and for the employer. Here, I would like to focus more on the same person, the employer, which under one case can be a user, and well, in the other case is called the employer, and how the obligation in two can interact. So I focused here in the obligation of users of AI risk, AI system of Article 29 of the AI Act. And I put in parallel the principal prevention of the framework directive on top of other key provisions such as the obligation of consultation, information, and training. So first of all, there is the concept of, under the AI Act, the user/employer should use the system in accordance with the instruction, so basically in a reasonable way, and they should keep the logs under their control. Under the Framework Directive Act, Framework Directive, that's really confusing. Sorry, Framework Directive. The employer should behave in a way that is ensuring the health and safety of the workers in all aspects of work, physical and mental. So, like mental aspect, psychosocial risk. My question is, does it mean that then the use of the software, and I hope so, should be done in a way that is ensuring health and safety at work? This is once again a cross-reading of the two in the way this software are going to be used. Then I would like to just raise some things about the instruction given. So Article 13 said that the provider should give access to information to the user, which here will be the employer, which I think should be concise, clear, comprehensible, and basically should allow the user/employer to understand how the software is working, how the AI is working, and to understand the input and maybe output. What I'm wondering here is that there is also an obligation of information for the employer towards the workers and the workers' rep. And if the employer is able to understand the instruction given by the provider about the functioning of the AI, why not giving this exact same information to the workers and the workers' rep in a matter of transparency here? That could be really, really useful when the workers' rep has to be consulted regarding the implementation of a software at the workplace, and also for workers to understand to which extent this AI might impact them. And then there was the final, yes,
you have a couple of minutes, yes.
Yes, there is the question of the human oversight that has been mentioned before. So under Article 14, the aim of this human oversight is to guarantee the safety once it's in use, right? Once again, I problem technical problem, but there is a detail of it. It's really for safety purposes. And I'm wondering who is going to be in charge of this human oversight at the workplace? Because is it going to be like workers who are going to upskill so they can be in charge of it, which I doubt because maybe some of them don't have the technical skills, or do we have to train the workers to understand how it works and to phrase basically to communicate the feedback of their work about how the AI might be not safe for them to the person which will be in charge of this human oversight, which might be someone new at the workplace. Once again, just questions about how it's going to work. And finally, my last point, really, really quick. So the place of the workers. In traditional system, the employer needs to assess the risk. Then there is a consultation of the workers rep, and then after this consultation, there is implementation of the preventive measures and information and training of the workers. This is the few points that can be raised in AI, but what is more important is there is one specific provision in the Framework Directive, Article 6.3c, that said that at the moment of the planning and introduction of new technology, this is supposed to be subject to consultation with the workers and their representatives as regard to the consequence of the choice of equipment, working condition, and working environment. And my point is, as soon as there is an algorithmic management system that is planned to be in place or introduced at the workplace, workers' rep need to be consulted almost at the same moment that there is the risk assessment. And I will go as far as even before the software is purchased, right? Because the way of consultation and the maneuver to adjust it to the workplace is quite small because of all the standardization that can be happening before it's on the market. So here the workers have their word to say about the choice of the software and also how it is used at the workplace. So that is my final slide. This is just, once again, a summary of all the points that I wanted to raise about the overlap of these two acts. And there is way more to say, just an introduction, but we should take into consideration because the main question here, and Miriam said it, it's who is going to do what and when. And here it's about the timeline and interaction between the two different actors involved or different actors involved. And for me, the only way to ensure that this software are going to be safe for workers is to have the complementary reading of this proposal with all the existing health and safety framework and obligations. Thank you very much. Sorry for the too much time.
Thanks, Odd. So Miriam and Odd have underlined the antinomies between existing law, especially labor law at European level, and the possible impact of this proposal if the text of the adopted regulation is similar to this. And it's important also to understand that health and safety has taught us that the risk assessment shall be done when the risk is actually part of the functioning of the machines, but also when the risks comes because the machines fail to do what they're supposed to do. So, and this is not really clear yet from the regulation. Last but not least, Valerio De Stefano, please, thanks for joining us, and the floor is yours.
Thank you, Vincenzo. Thank you for organizing this, and thank you for having me. It is a real pleasure, and it is of course very difficult to intervene after all these great presentations throughout the afternoon and say something still relevant and interesting. So I will try to sketch some of my thoughts on this proposal. And the first one, and it's the first concern, if you want, is that this proposal has been treated by the Commission, and in certain ways is also being treated by interpreters as a technical process, if you want. Whereas in my opinion, it is much more than that. It's much more of a constitutional process because it invests systems that have the potentiality to have implications on fundamental rights and on our societies for the next several decades. And there is by far not enough attention from the institutions, from the lawmakers on how much this can impact on our society. I have recently spoken about this at the European Parliament, and basically the idea that I got after speaking with some of the MPs that are following this more closely is that we don't want to be to stay behind and to lag behind China and the United States in terms of development of AI. And in my opinion, there's not really the comprehension of the fact that this has nothing to do with technological process, where nobody's saying we should not have artificial intelligence employed to do a lot of the wonderful things that the AI is able to do. But the concerns when it comes to the application to human beings and to basically expose human beings, and in our case, to expose workers to the systems that have been sketched so far. It is not the same. It's not the same to say we should use AI to fight climate change and to say we should use AI to improve productivity, or we should think that AI will help us overcome biases in the labor market. This has nothing to do with that. the proposal follows a very techno-deterministic approach that basically starts from the assumption that we will be able to control AI and to control the provision of AI in the market, and to avoid detrimental use and to avoid discrimination just by saying that we don't want detrimental uses and discrimination. There's not much really in specifically on how discrimination should actually be ruled out. There's an article in the proposal that says that basically training, validation, and testing data sets shall be relevant, representative, free of errors, and complete. Well, that is basically like writing in a paper in a bill that it shouldn't be raining. If we don't put in place the measures on the basis of which this should happen, these are just empty words, and it's really nothing specific on this in the proposal. On top of that, we see the kind of instruments that have been introduced in the labor market recently, using or purporting to use AI to manage people, and some of them have been discussed by Aude and Miriam already. But if we go back just a minute to this kind of machineries, we have the use of data tracking and based on GPS monitoring on how fast people go in a warehouse, how fast they go in the streets when they're on the bikes or with the cars, or how many keystrokes they give to a certain to the keyboard in a certain period of time, or how many emails they receive and send, and how fast they react to messages. All these measures of productivity that are used in and basically get factored into these algorithmic management systems are far from reliable, and basically they enhance managerial prerogatives in a way that is unheard of in the past. If on top of that we include another of the things that the regulation mentions, just passing by, saying, well, people should be informed when emotional tracking is operated onto them. So when you use AI to, for instance, do a facial scan to determine the kind of mood you are in, or whether you are attentive during a meeting or things like that, as long as you are informed about this, then the AI system is good to go. Yes, there could be additional legislation at the national level on that, but basically, insofar as the regulation is concerned, emotional tracking is good to go as long as you give information about the fact that your emotions have been tracked. This is extremely dangerous at the workplace, not only because emotion tracking on the basis of face scanning is basically snake oil, and no serious neuroscientist would buy that you can detect precisely and universally emotions on the basis of the facial scanning of AI. But on top of that, even if it was reliable, we shouldn't allow it anyway. It's arguably one of the most intrusive ways in which you can invade a private person's space, trying to read their minds. And if this happens in the context of employment, where people are already subject to extensive managerial prerogatives, this can enhance risks of invasion and exploitation that, again, are unheard of. And in my opinion, the regulation just gives for granted that once you have basically regulated access of on the market of this mechanism, and you more or less have ensured that these systems are more or less reliable and data and free of biases, then we should allow them on the market. But actually, this is actually when the discussion should be starting. Should we have this kind of monitoring? Should we have this kind of invasion on privacy based on an AI system, even if these systems were reliable? The regulation says, gives for granted that this should be the case. I think we should have a much more profound discussion on these systems, particularly the ones that are introduced at the workplace. There are another number of things that I think are worrisome when it comes to the specific context of employment. Aude was mentioning the question of keeping the human in the loop. So for you, high-risk systems, the regulation purports that you should keep someone, a human being, able to disregard the suggestion of the AI and control what AI is doing. If we allow machine learning, and especially if we allow deep learning when not even the programmers know what is going on in the black box, in the systems, and how algorithms update themselves and increment themselves, there is no way a human being can intervene, let alone having a person in every workplace able to intervene. But even if we were able to do that, the regulation does not provide specific protection for persons at the workplace that disregard the suggestion of an algorithm. So if you're a manager or a supervisor and your managers and supervisors have told you to follow the operation and the suggestion of the algorithms and you don't want to do that, well, if you disregard those suggestions, you do it at your own risk. You risk losing your jobs or getting sanctioned just because you didn't go with the suggestion of AI. I wonder who is really going to do that in the workplace if you don't give specific protection. So again, there's a lot of mouth-washing in this proposal, but when it comes to the specific application of the kind of safeguards that the Commission proposed are in the proposal, we see that they are really paper tigers. Finally, because I think I'm almost exhausting my time, a few words on the legal basis and how and why this, again, is another matter of concern. The legal basis, as it has been said, is a liberalization legal basis. It's basically the legal basis for the internal market to basically allow systems to be introduced in the market once they pass a minimum safeguard process, and then to spread around the union or even beyond. Now, this legal basis is the kind of legal basis that would prevent additional national legislation or existing national legislation to provide for additional protection on workers. And it may be used, this legal basis, also to disrupt those national legislations where you have to consult and inform trade unions or even get an agreement with the trade unions if we want to introduce certain specific surveillance system of the workplace. And the reason is the Commission is clear and the proposal is clear that they don't want 27 different legal systems regulating themselves, and every state can introduce the kind of regulation they want on top of what is already in this proposal. So if you have a national system that provides for co-determination in the introduction of this new technology, or it provides for, anyway, information and consultation, if a provider that has introduced a system in a certain given country in the EU finds that then transferring this system abroad elsewhere in another member state is made more difficult because in another member state the protection for workers are higher, we risk to have a new Viking level waiting for us. And I'm very afraid that the Court of Justice of the EU will rule that additional protection based on the workplace and tailored on the workplace are not proportional and will not be basically lawful because they actually hinder the harmonization process the Commission wants to take place. So we risk a disruption of existing and future labor protection that target AI and surveillance mechanisms on the basis of this proposal. Now, I'm not saying that the Commission wants that. What I'm saying is that probably they haven't realized the kind of stilting effect that this regulation based on this legal basis can have on workplace protection. To conclude, really, I think it would be much better to have a detailed and tailored instrument at the EU level that is based on the social chapter, whose legal basis is in the social chapter, that involves the trade unions and employers association in defining the instruments that should be allowed or not in the EU, and basically gives much more specific protection to workers than the ones that are already that are foreseen in this document. Now, when I've spoken to a number of NGOs and social partners about it, and they think this is unrealistic. They think that the Commission will not ever want a new specific instrument based on employment. It's much better to go with additional national protection. What I think they are missing here is that this proposal doesn't take into account, and it's not based on the idea that you have this general framework and then at the national level you do what you want. This is really not what a regulation is for. And this is really not what that legal basis is for. What they want is a uniformation of the market based on this. So this regulation risks being the ceiling of protection rather than the floor of protection, even at the national level. And with that, I stop, and thank you again very much for inviting me.
Thanks, Valerio, for reinforcing this concern about the minimal approach from the Commission on EAI and the outcomes, the possible conflicts actually with fundamental rights at work. It's the second time that in the second session we hear Viking and Laval be somehow named again. With no much further ado, I think it's time now to give the floor to our discussant, Tonia. Please, this is your turn now.
Many thanks, Vincenzo. I am honored to be invited as a discussant and to contribute to these debates on the AI Act proposal. I should start by confessing that I come at a disadvantage, which is twofold. Firstly, I am no expert on AI or digitalization. I do not have a great deal to add to the technical analysis offered by the experts speaking today. I expected to learn a great deal, and I have. Instead, my aim is to consider how these brilliant presentations could be placed in a wider context, especially in terms of the tension between economic and social objectives at play here, but also the relationship between risks and trust. And I want to look also at the relevance of the language of sustainability and just transitions. My second disadvantage, if I can put it that way, is that I live and work in the UK. And so post-Brexit might seem less invested in the outcome of an EU proposal on a regulation. Here, at least I can say that while any regulation adopted may not have direct effect in the UK, the significance of the EU in regulating the field of AI is actually likely to be considerable. It will be watched. As Rosanna Fanny's co-authored study for the Commission explained, when considering other initiatives, most countries are only at a nascent state of recognizing the influence of AI. In the UK, as her study observes, it was only in August 2019 that the UK Office for Artificial Intelligence published a guide, not a law, on using AI in the public sector. And that followed what was extensive use of risk-based verification being used by our local public authorities to determine an individual's eligibility for housing and council tax benefits. So this is already, having a palpable effect on people's lives. In the UK, there is now also, since 2020, guidance on AI auditing framework, which is a self-regulatory voluntary framework, but one which will be a source of reference for enforcement of our data protection laws, which obviously draw on the GDPR. Despite interest in AI as one of the grand challenges which has been identified in the UK's industrial strategy, the UK, like many other countries, is some way off introducing laws expressly tackling use of AI in an employment context. In that sense, there is likely to be a role on the global stage for the EU as a social actor in the field of AI, which was stressed in the Porto Declaration on the 8th of May this year. We find similar assertions of a desire to act as a global leader in social policy in the 2021 European Social Pillar Action Plan. It could be that the level playing field provisions in the EU-UK CTA relating to social protection and their uncertainties do prompt the UK to pay attention to what the EU does. But actually, I wonder whether this initiative from the EU is more likely to attract attention by virtue of its strategic positioning as a smart regulatory move that the UK may wish to imitate. I think there might be a form of mimetic pressure which occurs when states seek solutions to an uncertain situation by imitating those adopted by others as a way to establish legitimacy for their actions. There may also be, under the Johnson administration, an attempt to undercut any regulatory costs. China and the US don't have the monopoly on that. So let's see what the upcoming National Artificial Intelligence Strategy now holds for the UK. That will be published later this year. But I do worry that this EU initiative sets a precedent for employment issues as actually, despite being designated high risk, one of the AI issues which will be lightly regulated. And I suspect that failure to consider such issues as how transparency juxtaposes with trade secrets, as was raised in the last session, is exactly the kind of fudge that will appeal to the UK current Conservative government. As you know, the context for an AI initiative entailing a coordinated plan alongside a regulatory framework are the green and digital transitions which the European Commission stressed in its brief communication on a strong social Europe for just transitions. And you see echoes of that reference to digital transitions in the Commission communication. So here I'm talking about COM 2021-205, which accompanies the actual Commission proposal. And the Commission communication is explicit about the potential economic and social advantages of rapid technological development of AI, and states this desire, and here I'm quoting, to harness the many opportunities and address the challenges. The global leadership that's described in that Commission communication seems to be concerned with both, first, achieving a global competitive advantage, and again quoting, to provide European industry with a competitive edge, and that's explicitly at a time when there's a need to boost post-COVID economic recovery. And second, establishing an example of what the terms of fair competition should be. In this way, and I quote, EU action can facilitate the adoption of EU standards for trustworthy AI globally and ensure the development, uptake, and dissemination of AI is sustainable. So this is about EU competitive success and ethical leadership on the world stage. And an interesting question arising from the presentations we've heard today is whether these competitive and ethical objectives can so easily be reconciled. We're told, and this point was made at the outset by Guido Smarto, that the proposed legal framework on AI must intervene only where this is strictly needed and in a way that minimizes the burden for economic operators. And that tells us something, I think, about where any balance between the economic and social is expected to lie. So too may the narrow remit of the exceptions to which Guido pointed, and the uncertainty as to what are acceptable risks and is proportionate. And that, as Vincenzo said at the outset, is also an issue of what is not forbidden and left unregulated, which is huge. Of course, it's part of the language of sustainability and what is sustainable that economic and social goals can be reconciled. That's a facet of the 2030 agenda, setting out the 17 sustainable development goals, which are described as neatly integrated and indivisible. If they are reconciled and the risks of the use of AI can be tackled appropriately, then there can be trust, which facilitates economic prosperity and social peace, and possibly some environmental benefits as well. So much then turns on the methods by which that reconciliation takes place, which have been the subject of the analysis provided by our speakers today. I think it's really interesting that the chief regulatory tool is one of risk identification, grading, and management. That approach and its dynamics were set out brilliantly in Guido's presentation. There are to be, of course, measures to promote transparency and ex ante, ongoing iterative and post facto risk assessments, including potential for human oversight, which, as Valerio Di Stefano has pointed out, seems unprotected. The Commission's communication and does seem to envisage significant funding for investment and perhaps enforcement, but we're not sure whether it meets the needs that Frank Pasquale highlighted. Less space has been made for the specifics of collective worker representation and its protection in these processes. As Ord Cefalialo has pointed out when explaining links between the proposed AI Act and OSH, we've become very familiar with risk regulation as labour lawyers assessing COVID-19 safety and health measures. And that's been managed under the Framework Directive on Health and Safety of Workers, to which she referred. As she notes, the design is different, which makes their interaction complex. And I think it's an important comparison to make, given the failure of risk assessment processes and procedures in many countries in COVID times. For those interested, Peter Anderson and I have written on this as part of a Swedish Research Council project, and our article on risk assessment will be coming out in the special issue of the Comparative Labour and Social Security Law Journal later this year. And one of the failures we found was the presumption of safety, the trust that followed risk assessment processes. For example, in the UK, the label COVID secure, which employers could use after a risk assessment, created a false sense of confidence in the often formalistic measures that have been taken. Trade union voice challenging the assessment of safety was disregarded at a considerable cost to lives and health in this country. One would not want the same failings to apply in an AI context, whereas Valerio has said there are considerable risks associated with AI and employment. And those are, of course, reflected by the European Commission's acknowledgement of those high risks through their inclusion in Annex 3. And I like Wood's point that information and consultation could be built in through a complementary reading with OSH, but is that really sufficient? I think it's unlikely, given the product safety paradigm on which Michael Veal has spoken and the potential trade-off between respective obligations that arise for the providers and users of AI systems, to which Miriam Coleman has pointed, and also which gives scope for that regulatory arbitrage which Frank Pasquale identified. It poses problems for OSH too. Overall, I share the concerns that Valerio has voiced. I too worry about the legal base for the measure and its implications. I was involved in advising the ITF on the Viking litigation. We wouldn't want to repeat that. While certain fundamental labour rights do see forms of protection here, and the inclusion of platform workers stressed in the preamble is welcome, I also really worry about the scope for social dialogue and collective action here. Social dialogue was recently stressed as vital to a digital fair transition as a facet of sustainability in the Porto Declaration, but it doesn't seem to be given sufficient space in this proposal. And as Valeria has said, this obviously has implications for reconciliation of the regulation with existing information and consultation obligations, but also the potential scope for collective bargaining on such issues at national level. I've argued elsewhere that sustainability entails, in ideal terms, first, durable, longer-term policy solutions. Second, a holistic treatment of economic, social, and environmental objectives at interlinked global, regional, and national levels. And third, last but not least, a dynamic, participatory, inclusive approach as the route to achieve these. On the basis of the presentations which were given today, I'm not yet convinced that the proposed regulation laying down harmonized rules on artificial intelligence, the AI Act, will actually be sustainable. And for now, I'm going to stop, and we should probably hear the views of our audience. Thank you.
Thank you so much, Tonya. Thanks a lot for, well, commenting on the talks and adding on top of that your own knowledge. You were not supposed to be an expert on AI. We are a labor law community here organizing this conference. We just wanted someone with the knowledge about fundamental rights at work, about collective bargaining, just to somehow filtrate and somehow digest the technicalities and transpose them into labor law fundamental rights perspective. And this is exactly what I was expecting from you, and this is exactly what you delivered. So I'm very thankful for your intervention. Now, as Tonya was saying, it's the time for questions and answers. I don't see anyone in the chat proposing themselves for questions. I now ask if there is anyone willing to intervene. I also ask our panelists to turn on their cameras. It's been a long day, and we all have, this Zoom fatigue on our shoulders. So it's completely understandable if there is no question, but I don't know which one was first, but maybe Valeria, I don't know. I mean, maybe my eyes are not. So please, Valeria.
Yes, thank you. If I can, if there's no question, of course, from the audience yet, I would have a question for Miriam, and thanking again for her presentation. I was curious to hear your opinion about this provision in the AI proposal about the testing, validation, and training of data and all the beautiful thing that we should expect from it, but actually how do we get there, and will it be ever possible to get the kind of safety that the Commission thinks we can get?
Should we collect first 2 or 3, Vincenzo?
Yeah, if there are 2 questions. I don't know, Odd, on which terms. It's a totally different question.
It was more a comment, so I think it will make more sense if Miriam answers right away.
Yeah.
Okay, thanks. Yeah, about the testing and validating provision. I think I need to read it more in depth and think about it. But I'm a bit skeptic, I must say. But I would suggest give me some time, and I will contact you via email and we have a chat. Is that okay?
And then Odd, please.
Yes, it was just to say some comments about actually the presentation of the other speakers and like bouncing back a bit on what Tonia said when she said that it would be, her fear it would be lightly regulated. Well, the fear is that this light regulation will be the norm, as Barrier underlined, that because it would be a regulation, that would be a ceiling and not a floor. And that's really worrying, that that would be the norm and there would be no space for adapting on the workplace consideration. I really have the feeling that there is this market expectation put on the workplace reality with no space for adjustment. And here, actually, we should ask, when we do that in the workplace, what is the purpose of introducing AI at the workplace? Is it actually necessary? And are the impacts actually like balancing a bit the benefits of it? We need to ask the reason and the rationale behind. And here, this is why the discussion also, be it on OSH or other form of collective discussion with the workers are fundamental. And also, just to quickly echo what you said about the fail of safety and the presumption of safety, Tonia. There is somewhere, I think, in the Act, a presumption of conformity based on robustness of data, which I think will be a dangerous path, is for employers to say, well, there is a presumption of safety because it passed, there is a conformity assessment, but on the other side, there is a presumption of conformity based on the data. So it's like presumption on presumption, and we have no idea of the actual impact. So we need, once again, to really cross all of this and put that to the broader context. So yeah, that's just some thoughts and reflection that came to mind after hearing all of that.
I don't know if, Tonia, you want to comment on that?
No, I think that I completely agree. I think that one of the real difficulties has been in the context of risk management around COVID has been the scope of managerial prerogative and collective worker voice. And I know that's come up in Sweden and in the UK, managed much better in Sweden than in the UK, I should add. But I'm not suggesting that risk assessment is necessarily a problematic route. I'm suggesting that it can be when you cut off access to worker voice and you don't get those continuous iterative processes which do respond to, in the context of COVID, for example, subtle changes in emergency. I think subtle changes in algorithmic developments or in forms of information management in the workplace would raise similar kinds of concerns. And yes, I would want to see that fleshed out. And without significant access to collective bargaining as well as information and consultation. Yeah.
And on top of that, we need to remind that in a total controlled workplace, workers wouldn't be so keen on organizing and protesting, right? So the more control, the less possibilities on organizing themselves. Rudiger Kraus also wants to intervene.
Okay, thank you very much. I think there should be one intervention from the audience. First of all, thank you very much to all presenters. You raised a lot of questions, and I think it's impossible to deal with every issue you raised. And I've learned a lot, as Tonia said. I can follow only. I've only one question. Tonia, you raised the issue of social dialogue. Is it, or could it be, an instrument to cope with that questions? My impression is that social dialogue could be, to some extent, a tool on the level of the establishment. Perhaps it's a typical German point of view. We have works councils, and they have. It depends much if you look in different firms, but in large firms, works councils are quite strong. And the question is, but sometimes to get let's say the expertise, it is. Even if works councils have the right to oppose and to have a say on the introduction of, let's say, new technology and AI and so, the question is how to get information on the issue, how does it work? And it might be of interest that the German legislator now introduced a new provision in the Works Constitution Act that the Works Council has the right to charge an expert on AI questions. And this it's only a small tool, but I think it's important to to empower workers' representatives to have knowledge and skills and expertise on that. And my question would be, not only to you, but also to the others, are there any ideas at European level to enlarge the let's say the options for workers or employee representatives to get information and skills and something like that? Because this is, I think, an important tool. Yeah, thanks.
Yes, Tanya, please.
Yeah, so the Commission communication that accompanies the proposal does talk about skills. It's not clear how those skills would be acquired or what form of investment there would be in them, or whether there would be any form of collective input in terms of worker voice into how that would be managed. I mean, I think if you go back to the Porto social commitment, and they talk about this commitment to promote autonomous social dialogue as a structuring component of the European social model and strengthen it at the European, national, regional, sectoral, and company levels, with special emphasis on ensuring an enabling environment for framework for collective bargaining within the various models that exist in member states. I'm not convinced that this proposal does that. Either when I look at the Commission communication or the explanatory memorandum for the AI Act, it's about the question of the legal base. As Valerio said, if it was a different legal base for employment, we would see much more engagement with the social partners on these issues. You're right that there could be engagement at Works Council level, and I think that is possible. That would be consistent with the Porto social commitment, but it doesn't seem to be built in here. I mean, I've read this and it's a long document, and I'm not sure I've grasped every aspect of this. So perhaps Ord and others can tell me if I'm wrong about that. But yeah, so I would be looking for that really holistic engagement, social dialogue that's there, you know, which was agreed in May, but which doesn't seem to be altogether reflected here.
Thanks, Tanya. Odd also raised her hand, so she...
I want to underline that Valerio also raised physically his hand before I clicked. So he wants to say something, I think. But just quick answer to the question to Rüdiger. Well, I go back to the Framework Directive, not to the AI proposal here, but in the Framework Directive, Article 11.5, it said that the employer should provide the workers' representative with the necessary means to enable such representatives to exercise their rights and function deriving from this directive. Of course, it's not all a matter of OSH, but in some member states, necessary means are understood as access to expertise, because only with this expertise, you empower them. They are in the capacity to understand what is going on and then be actively participating in the debate, in the consultation. So I will rely on this and have a broad understanding on OSH as a way in. That would be, once again, my OSH approach.
Thanks, Odd. Valerio.
Thank you. Adding on what Tonya and Odd just said, I think we have, in my opinion, we have a problem on how the Works Council will ever be able, if any, to contribute and to veto and to know what is going on. But my concern is that, and I've seen the same phrase about skill in the commission, in the Commission communication, right? This is not a question about skills that can be transferred to a single person in the work, a random worker in the organization. It is very doubtful that even employers know what they are buying, leasing, renting, especially if we're talking about small and medium enterprises. I mean, when we talk about this system, we always have concerns about Amazon or Google or whatever, which have their own problems, but at least more or less know what they are doing, more or less, because even Amazon had to withdraw a system they had implemented because it was discriminatory. Imagine what happens in a small or medium enterprise. Who is ever going to be able to give answers on what they're buying or leasing? I mean, unless you involve the programmers, so you really have a provision that obliges the provider to be present in the information and give actually the kind of answers that you would need to even know whether these systems are reach the bare minimum level of safety before being implemented. I am not sure not even the employers can do that. And this is not just about, we don't even know who the user, yes, we know the user is the employer, and we know that the regulation gives some obligation also to the user. But I mean, again, you can say that the user has obligation, as you can say that it shouldn't be snowing, right? But you can't control that. And again, the problem of techno-determinism is really this, that you think that you can control this, and you have the society in general, employers, workers have the skills to prevent the most detrimental use of these systems and to prevent the negative implication that can stem out of it. And I'm afraid this is really not the case, not because of lack of goodwill, but it's because it is just impossible to have this in every single firm.
Thanks also to Valerio for giving Rudiger a comprehensive answer to his question. So I don't think we have any further question. It's almost the time to round up. So once again, many thanks. Miriam unfortunately had to leave a little bit beforehand, but of course Miriam, as well as Odd, as well as Valerio, and of course Tonia, many thanks for being with us today and for providing us with such incredible and inspiring speeches. I think that at the very end of this long afternoon or morning, depends on where people are joining us, we can definitely leave with a little bit more of certainty. Unfortunately, it's not for the bad, for the good. I think that many concerns have been consolidated by our panelists. And so we shouldn't be very happy about the things that we learned today. I'm very Gramscian when it comes to this. I think that being aware of the challenges, it's the first step to tackle them and possibly to overcome them. So I don't know whether how the next steps in the adoption of this proposal will go. I think that one reasonable thing would be to scrap altogether every reference to employment and labor in general. But then it's a matter of political confrontation in the parliament and in the council. But I think there will be plenty of room for us to meet again and discuss these incredible and fascinating issues of how technologies are impacting on labor law on its very foundations. So once again, thanks a lot to everyone. Thanks a lot for being here with us today, and stay tuned.